Recording? Yeah.
Welcome, everybody. This is another episode of Operation Wisedome. It is powered by power inherent in the people. Today is Saturday, January the 31st. We are in 2026. Everybody, why don't y'all unmute here in Operation Wisedome and y'all say hello, world.
Hello,
Hello,
world.
everybody.
Hey,
Hello, world.
everybody.
Bro.
How we doing, everybody?
What's up,
Welcome.
Cameron?
Peace.
What up?
Hello, hello.
All my peoples, I love y'all so much. I just want y'all to know that y'all like the foundation of like real change in this thing. It's crazy, bro. If we just keep pushing, we just continuously keep growing, and it is growing, bro. It's consistently growing. So, man, it's just so humbling to know that there's a lot of good people like y'all that are standing up not only for yourself, but for your children and for your grandchildren and for the future generations. It's not just about you. You know that. If it was just about you, you'd be like everybody else and just acquiesce. You just do as you're told, clearly. So, yes, today we're hosting a very special guest, my boy Michael. Hey, man, he's down in California. He's been doing his thing. He's got as you see, that's the opening of this video, is his car getting pulled over and then having to deal with everything beyond just the pullover. We're looking at like almost close to 2 years in relation to dealing with this situation. And as hard as it's been for him, he's coming out swinging hard, learning and standing. And like everything else in this field of arguments or claims, whatever being brought forth against you, it's all about standing in capacity as far as knowing who you are. And once you know who you are, you research and figure out how to implement that in the way that's kind of set forth. And if it's not there, then, well, you're going to have to tread the new way, right? And so I think the time and effort that Michael's put into his situation is very humbling too. It's like, bro, you know, when you see some people just take what they can take and then just keep going and researching and piecing together and then, trying to build even more from others. It's exactly the same thing. You kind of remind me of myself. So it's real cool that we have that same kind of mentality as mostly everybody here is learn what we can, you know, chew the meat, spit out the bones, right? And then implement that into others. And that's the beauty of Wisedome is one mastermind that comes together to make, one whole unit that's benefiting people. We see so many dismissals, and then we see some that are hidden, deals being taken. I think we just had a deal recently that kind of was all the charges were brought down to infractions, and so sometimes they don't want to let go, but that don't mean you can't pursue forward on damages. And I definitely think that's something that Michael's probably going to be having to deal with here soon as well. So to everybody out here in Operation Wisedome, I wanted to introduce Michael, let him come in and introduce himself. Michael, why don't you go ahead and introduce yourself to everybody out there?
All right, everybody. Welcome to Wisedome. It's a pleasure to be here. I'm glad that I was able to make it. I'm usually busy on Saturday mornings. But my name is Michael. I've been representing myself for about 2 years in a DUI case that initiated with a public defender represent me, which I found very soon that he did not have my best benefit in mind. And so he had to go. And that was done very quickly. And then I kind of took over and I've been handling this thing by myself. And it did extend to a writ of mandamus that I filed against the DMV in a totally unrelated case that I actually have trial coming up this on the 13th of February for that case. Trial for the DUI is on February 9th for the underlying criminal matter. So welcome. Time to learn some things and time to kind of see my journey. Hopefully it inspires some people. Hopefully it shows you that this is not for the weak. It's not for the faint of heart. But when you know that you didn't do something, when you know you're right, and you know that the system's being levied against you, you really got to apply yourself, apply the knowledge that you learn. I definitely advise you to tap in with like-minded people like we do here on Wisedome, because that is definitely a beneficial interest to you. There's power in numbers, and you know, Cam's got a really special thing going on here, and there's a lot of really special people in here. I could tell just from the few that I've already met and some of the things that I've listened to, and browsing the Discord channels and just kind of reading on some people's stuff. So welcome. It's a pleasure to be here.
Thanks, bro. Yeah, we're glad to have you, man. You've been putting in some work for real. If you are an Operation Wisedome donating member, you're able to get access to pretty much almost everybody's situations going on in Wisedome, and his situation is definitely one that you can learn from and see and incorporate into your own. It's a beautiful channel. There's a lot to it, but again, it just shows you what some people have to deal with in certain jurisdictions, in certain places. We're all out here sharing what we're going through, and that's the beauty of it all. How do we, maneuver the best way possible based on everybody else's experience? So what I want to do is I want to start sharing, and maybe we can just speak on this video like we've spoken of before. We've spoken a lot about this, so I don't know. I think it'd be cool if we just be jamming, bro, on the cool from what's going on because the audio's so bad. You know what I'm saying?
Yeah, it's awful.
What do you think? You want to do it like that?
Yeah, we could do it like that. Just maybe to help people. Preamble before we get into this video, y'all. Just understand that this video is highly manipulated, highly distorted. I have no doubt they gave me 2 videos with this exact same dash cam. The second one we're not going to include because it's really fucking long and it's kind of useless. But in that second video that they produced, the language and the audio is very fucking clear. You can hear me having a conversation with the 2 deputies from like 25 feet away, whereas in this video we're only 5 to 10 feet away. So I definitely will be using that in a future, lawsuit case. That they highly distorted this video. So understand that you will be dealing with certain things. The DA will throw all kinds of crazy bullshit at you. So they've cut out a lot of portions of this video. They made this about 15 minutes long from the point of detainment. That's intentional because anything longer, any detainment that's longer without an arrest is unlawful. Well, the actual detainment was about probably 25 to 32 minutes. It's not included here. So just be aware of these kind of things. And mind the way, you're not going to know this because they've manipulated the time edits and all that stuff to kind of fit. They're really good at what they do. So just understand, we're going to go through this. If it's hard to hear, it's not your audio. It's just how they produced it.
Well, one
So,
thing I want to
real
say too, sorry, just real
go
quickly,
ahead.
because I remembered that I put it in the chat. What I ended up finding out through the Yakima situation, through their dash cam footage, is that while we were doing the live, actually, wisedome, there's 2 sets of audio on one video file.
Mhm.
So if they have the, I'm maybe this dash cam footage, if I download it again, it may have 2 audios, and you could switch to figure out which audio you wanted to utilize. That I found out by throwing it in the CapCut. So maybe I just download it again and then check in CapCut to see if it's got 2 different audios.
Interesting.
And if so,
So
pick that other one, because that's how it was with my Yakima video that was produced to me from them.
that's interesting. So it sounds like there might be 2 audio streams in that media file. So kind of like a different language set or something. But anyway, it's an audio stream embedded in there. That's interesting.
Yep.
So, but real quick, Mike, are you saying that the timestamps, the date and timestamps in this video, the green text is all manipulated or at least changed?
Just the timestamps, yes. The date is correct. The timestamps is manipulated. You'll see a lot of flickering. So
Wow.
you'll
Okay.
see a lot of flickering. What they did is they cut out portions of the video that would benefit me. That's exculpatory because I'm saying certain things to protect myself.
Sure. Yeah.
So they cut out certain portions and they combine it to act like that portion never existed by keeping the timestamp consistent. You'll see the time frames never really change. It's pretty smooth in how it's consistent. But you'll notice these little flickers, and in these flickers, you'll notice that the timestamp has like a very, very, very small delay sometimes. Almost unnoticeable. Yeah.
Okay.
Right there was one.
So he asked for his driver's license. Okay, I know it's hard to hear, but he asked for his driver's license. He said he pulled him over because he said they were swerving, but he asked for his driver's license. Homie was like, "Hey man, I was in between the lines. I'm driving good." He said, I didn't say you was driving out of the lane. I said you was driving out on the line." He goes, I think Michael says, I don't think I did. He goes, yes, you did. And so your driver's license. What did I do wrong? Oh, shit, sorry. I just told you. All right, go ahead and come out of the car. Come out of the car. I'm ordering you out of the car.
So what they cut out there is I said, well, you need to articulate to me what I did wrong. Are you giving me a traffic ticket or what's going on? He said, well, right now it's an investigation. I said, well, an investigation is not a crime. So at this point, I'm going to refuse to give you ID. The reason they took that out is because that would be the no consent, right? To where it becomes non-consensual. They took that out.
Let's check and see if there's a second audio. No, I need Launchpad. Where's CapCut?
If you have VLC player, you might be able to see the different audio streams in there.
Well, CapCut usually be hidden for you, boy.
Yeah.
Yeah, I be jamming. With create, Brett wants to come in and then share. this one and share. And then where'd the file go? Cam wants to come in.
After your little meeting or whatever.
Let's see. It looks like there's only one track. There's only one track on it. But let me try.
This is it.
What's it? What are you talking about? We're trying to find to see right now if my boy can.
Sorry, I didn't have mute on, Cam.
It's okay. We're trying to see if my boy has two different. Whoa! What's weird though is that when you do load the video right now, the green actually popped up later, so that's kind of weird. Select speed audio for past few. Man, I remember on the last one through Yakima you could pick, but I don't see it, bro. I think it's really only just one. It's showing us one audio. And I don't know if we did it. I don't think we did it through VLC. I think we did it just straight through here. Remove audio, remove video trim. No. What's on here? Playback? No. Okay.
If you got a FFmpeg on there, you can just see what streams are in the video stream and the audio streams, and it'll list them. But anyway, if you want, we can work on that later.
Yeah. 443. 443. So I can bust up the audio for you.
They cut out a lot of stuff that makes me sound like I'm talking weird.
Say that again.
They cut out a lot of conversation right there, and it made me sound kind of like I'm aware, just out of nowhere. There was a lot that was said that they cut out. It's frustrating.
So I do believe within 60 seconds of contact that he asked him or requested him to get out of the vehicle. Yep. And again, what grounds were there as far as safety that was being posed, or a risk that was being posed as far as safety is concerned to the officer? There was none. It was just really a request that
he had a motive.
Order. Yeah, there was an order there. And so that order, was it valid or was it not valid? Y'all tell me, was it a valid order to exit the vehicle or not?
Invalid.
Not unless he's posing a danger.
Invalid.
He didn't articulate any crime.
Not once.
Or suspicion of a crime.
Or any danger.
Or an infraction.
Somewhere in Title 18, it says it's unlawful to remove a captive from his vessel.
There's the J Treaty, too.
The what?
The J Treaty.
Jayy?
Jay.
Just Jay?
Jay. The J Treaty. It's a travel treaty that we have the right to travel without being harassed by any kind of government.
It's been long standing, bro. That's why I say we got Supreme Court justices here in Washington be straight up saying that shit, and it's like
because it all derives back to the J Treaty. That was the first official treaty document that basically said we have the right to travel without being imposed by arbitrary government stopping us for no reason.
That's cool and all. I feel you on a document that you feels might be the first, but bro, this is the land of the Bible, bro.
Yep.
Like, I ain't even trying to hear that. I know what this is, bro.
Yep.
Like, this is the land of the Bible. You're not gonna sit here and tell me I can't just travel freely on God's country, bro.
Yep.
Where civilization and life like literally started, bro. I'm not finna play about this. We know this. Like, we free here. I shouldn't have to have a document from some date that is irrelevant in the consideration that we've been here in existence for so long. It's wild to me. I'm gonna keep going. Sorry. Damn.
Come out of the car. I'm ordering you out of the car now. Okay? You have to tell me what crime I already told you.
And Michael says, you have to tell me what crime I've committed. And Homeboy says, I already told you. I know at some point in here, though, I did hear that there's a distinction between a crime and like a traffic infraction.
I'm making sure you're okay to drive.
Making sure you're okay to drive.
I'm outside so I can speak with you. I don't appreciate what that is doing. But I find out here, I'm just doing everything. Well, it's not okay. If you're fine to be driving, you're going to be on your way here in 2 minutes. Let's go ahead and step up. Go ahead and step up.
Pause it real quick, Cam.
Real brief. I'll be real brief. He just said if you are fine to be driving, you'll be out of your way in 2 minutes. All right, let's find out if that happens. Go ahead. Pulling up my pants.
I did not commit a transaction. I was out of my lane. I didn't actually I was out of my lane. There, brother. I'm not going to drive my driver's license if I didn't you see echo here. I didn't I'm in the lane. That's why when you echo up, what's going on here?
Man, I wish there was 2 tracks. I can hear it. What's crazy is I can hear the echo.
Yeah.
There's 2 tracks.
I wonder where that feedback's coming from.
That's within the video itself.
Right. Like where's that getting picked up at on the mic?
I'm very aware of where I was. I'm very aware of what's going on. It'll show him that I was out of my lane. Therefore, I'm not driving. I didn't talk while you did you follow me? Okay. So you follow me. If I move left lane, and if I did not move from left lane, I was in the lane. Please left the lane. So what?
Man, it's so weird. So as soon as Michael requests a supervisor, he gets placed under arrest as well.
Which is totally not what happened, by the way. I requested a supervisor. He said, that's my supervisor right there, pointed to another officer whose name's Officer Jackson. And that officer came up to me and said, well, you take a breathalyzer test. I said, no, why would I need to do that? And then he said, that's it, do what you got to do, and walked off. And that was supposed to be the supervisor, but it's not. The real supervisor, I found out, was after they arrested me at the detainment center when he was trying to get a warrant. The real supervisor came in and introduced himself. I said, well, hold on, you're the supervisor, you're sergeant? You're Sergeant Barajas? He said, yes. I said, well, who's that guy over there? And I pointed to Jackson. He said, that's Officer Jackson. I said, so he's not a sergeant? No. He's not a lieutenant? No. He's not a supervisor whatsoever? No. So I looked at Flores, who arrested me, and said, why did you tell me that he was your sergeant when I asked for a sergeant? And why did you act like you were the sergeant? And why did you guys not present a sergeant to me when I requested it during detainment? Craziness, guys. So the officer lost his qualified immunity multiple different ways. 1, he lied about the sergeant coming. 2, he terminated the FST way prematurely when I asked for a single clarifying question in the very beginning. And 3, he arrested me without probable cause. That's why I'm dealing with what I'm dealing with, guys. And this is the same thing that you may face if they are trying to cover an unlawful arrest to prevent a lawsuit. Because my dumbass did say that I was going to sue them after they had already arrested me, when I found out that the sergeant wasn't the sergeant, my dumb ass being pissed about the whole event said, I'm going to sue every single one of you guys. And that's where I fucked up. Don't ever do that. Don't ever tell them what you're going to do. Keep that shit to yourself.
First Amendment auditors that claim that they'll do. And that is a terrorist threat on a public official. So don't do that anymore, people.
Yep. Do not do that.
Say that last part. I didn't catch it.
Ralph.
Was that you, Ralph?
Yeah.
Yeah. For arresting like First Amendment auditors that claim that they'll do civil litigation, that becomes terrorist threats on a public official.
That you'll sue them is a terrorist threat. Telling them that you'll sue them is a terrorist threat. Is that what you're saying?
Yes.
In what jurisdiction?
I don't know.
How is that?
Many of amendment auditors still sitting in jail because of that.
Guys, listen, he's not saying that it's lawful that they do that.
No, I get it. I get it. I'm just surprised that they're saying that.
Oh, don't be surprised, brother. They're going to say all kinds of bullshit.
Oh, yeah, that's true. It's interesting that they are saying that saying you're going to sue them at a court of law is a terrorist threat. It's just interesting. So that's all. I just wanted to clarify.
What Nazi jurisdictions are saying that?
So they're saying that in relation to the 10-mile radius corporate jurisdiction. That's what they're saying it to. Because anytime you threaten to sue an officer when they are essentially performing their duties, right? They're going to say anything and everything they can to try and prevent this. Especially what they don't want is it to become common knowledge for people to understand their rights and know what's going on with the courts. So they're going to crack down on us, people like us, very hard, and they're going to use any method possible. That's the only thing I could think of is officers are supposed to write citations and arrest people for certain things, right? So if officers fear they're going to have civil litigation levied against them just for trying to do their job, just perhaps they make a mistake and do it the wrong way, that is what they're trying. That's probably, I could only assume that is what they are trying to infer is a terrorist threat.
Where I'm trying to find out where in the United States of America is any like jurisdiction enforcing a policy or a code or an ordinance or a law about that. Because I want to investigate that.
I would love to agree to.
I yield.
They're allowed to legally lie to you.
Yep. He who can be manipulated or he who can be deceived shall be deceived. So if they throw some bullshit at you, you know how to get rid of it.
Let me ask you a question, sir. Look at smell like I know I am very well, that's my right to say that, sir. I did not speak on my name.
Come on, it's very weird. Oh, I did hear him, but it didn't sound like anybody asked you right there if you wanted to do any tests. He just straight up said,
yep. They cut it out.
He just straight up said, do what you got to do.
Yep.
Okay. So essentially,
Yeah, exactly. You're not letting. Listen. Okay. So now, you pull the veteran to pay your service. But now, that being said, let whoever's investigating officer tell you what they saw. You don't see it the way we say. Put you over. Not because we're out here bored. It's fucking in the morning. There's obviously something that got their attention. So and if they determine you're right. What does that have to do? Stop right now. Yes, I do. What does that have to stop right now? I have the right not saying that I have a lawyer. No, okay. That's easy. Don't start. But I'm going to tell you, you don't get a lawyer right now. We don't have lawyers on standby. Once they're done doing what they need at that point, they'll advise as far as your reputation. So stop. Whatever you're seeing, that's false. Okay. Trust me. Okay. I want to better. I didn't say anything. I was investigating. Their investigation told me I was if I went left lane, I went right lane. You want my if I investigate, they're investigating something right now. Okay.
It's like I want to be able to move to the left or the right as far as audio is concerned to isolate. You know what I'm saying? But I can't do it because
can you mute the video?
Well, I isolated the audio, but I don't see the option to give me the eligibility to move it to the left speaker or right speaker like normal. That's what I'm saying. The left portion of the audio or the right portion of the audio. So we're hearing like this delay between left and right. They're two different audio sources meshed into one. That's what's going on. So like if I had the eligibility to, let's say, it's just because it's so annoying, bro. But if I had the eligibility to
can you just try to mute the video audio and see if that works?
I don't think there's no eligibility to do left or right in here either. Man, that is so trash, bro. Audio, prefer pass-through, loop spatial. I mean, maybe in VLC I could do it, but it's not giving me the eligibility to do it here. Or in CapCut, which is crazy.
You're wrong for this. Now?
Well, when it showed the timeline in CapCut, the left of the video.
No. Investigation is not a crime. Yes or no? Investigation. Stop it. It's hard to trust you guys. I want to trust you guys. I want to believe you guys are on this word. Okay, so here's how to report, okay? You're going to let her know that question about possible repair, okay? They're going to have you do a couple steps to determine, okay? But at this point, you're paying attention because you're unstable right now, okay? So right now, they're going to let them have two questions. But we need to see like
And then he asks us again, we need to see your license. So they're going through this whole process here where, let's see, I guess they get you up on the car once.
If you're doing an investigation, I want to help with this. Hi guys. Well, Don't know better. We know better. We got our way. I'm listening to you guys. Is your fan on? Somebody bring out that. No. Come on, let him know. That's not how it works. You guys really want to look at this. Now you're illegally taking items from my home. Brother. Come on. Hey, listen. Guys, better. If I was like, I'm not going to go to all my friends and family and say, guys, don't talk to me. You want me to tell you that I'm talking about more? I'll work with you, but so much of that. You just sit down and there's not anything wrong.
So they end up arresting my boy. Looks like what do they end up doing with everybody else?
Telling them to get out the car, and then they ended up towing my car.
They end up towing your car?
Yep. And did anybody notice the car that parked to the right of me? It was a woman. She parked all fucked up.
Yeah.
And they just let her go. And I parked perfectly fine. And yep. Interesting.
Okay, so what we got going on is, I guess what you need to start explaining is what's been going on. And after getting arrested, what transpired?
Yeah. So after getting arrested, they took me to the holding center. They needed to get a warrant because I said, I'm not going to give you my blood. They said, we're going to suspend your license. I said, do what you got to do. I'm not consenting to give you my blood. So he got a warrant. Should we show them the warrant? It's a 5-page document. It's a 4-page document. It's very easy to kind of pull up.
Yeah, let me see. Is it in the Discord?
Yeah, it's in the Discord.
Where do you think it's at?
Let me see.
Did it have a judicial seal stamp on it raised?
Oh, nope, it's bad, guys. You guys are gonna laugh at this shit. It didn't have anything. It didn't even have probable cause. It didn't have anything. Here, if it's not in the Discord, I'll upload it right now.
Okay. Yeah, we got a lot in here, bro.
Yeah.
Yeah, there's a lot in here.
What I'm gonna do.
My boy. These which one you're gonna have to tell me too which one is for sure the
Hold on, brother. I'm gonna bring this up for you real quick.
It's okay. I'm just going through the hearings, which I got 2 of them pulled up. Wait. Initiation of hearing, yeah. Because I want to most definitely allow people to hear how you made the judge yell. That was kind of crazy, bro.
It was wild.
Yeah. Like that was wild.
All right, so I put a notice of lodgement into the Discord chat. If you go to page I believe it's 24, 25, 25 through 29. And then while we go over this, I'll also tell everybody how things went down. So they took me to the holding center. They got a warrant. The warrant we're about to show you, the officer fails to articulate probable cause anywhere. On the warrant, he fatally fucks himself by saying the vehicle was swerving in the lane. Coordination is normal. So we're on 25 right now, Cam?
Mm-hmm.
So that's the warrant. That's the warrant return. That's what the magistrate that reviews the warrant and approves it basically says, "Yeah, I'll stamp on it, send it to you." Blah blah blah. That's pretty useless. You see where they put the seal over the signature block, guys? This is not ordinary. The seal's supposed to go to the right. There's a designated area. By the way, it's electronically signed. It's supposed to be signed by a wedding signature to avoid rubber stamp warrants. That's State versus Pollock. It is not. If you go down more, Cam, the first page is the search warrant affidavit. You can skip this page because it's basically just saying it tends to show that a person has committed a violation, blah, blah, blah. And you can skip the next page too because that's just an attachment A. Yep. And then here's the page we need to look at. Affidavit of fine declarant. So it's just a bunch of boilerplate reasoning with bullet point like check boxes, right? Important to note, vehicle was swerving inside the lane under other reason for investigation. The suspect was identified as the driver of the vehicle by observation. Objective signs of impairment. By the way, objective and subjective are defined very differently in Black's Law Dictionary. I've got the definitions if you guys want me to tell them. But if you look at this is the affidavit. This is the kind of shit they'll use against you guys if you don't agree to give your blood. They'll probably do some shit like this. And under coordination, you see it's normal. He checked that. That's where he fucked himself. Everything else is just subjective cues that he could. I mean, you can't prove any of this shit, right? Insulting. He checked insulting. Did you guys hear me insult them at all?
Well, still sounds like freedom of speech.
Yeah, 100%. It is freedom of speech. I could say you're an asshole if you're an asshole.
It's so funny too because it's like if you're supposed to be like, if you're supposed to be like honestly like drunk or something, you would think the speech would be like slow, mumbled, slurred, but neither one of those are checked, bro. It's rapid. Like, okay, well that means I'm on point right now.
And they say that I was repetitive. Well, that's because I'm sticking to my guns. I'm not letting you obfuscate the conversation. I'm asking you specific questions. And then if you go down one more page, guys, the field sobriety test, this is where we get them. Guys, a judge signed this, by the way, right here. Subject refused to cooperate at the time of contact, by the way. That's important to note. And was placed under arrest for suspicion of DUI. Does that sound like probable cause, guys, or does that sound like RAS?
RAS.
Yeah. Yeah. What's the standard for arrest, guys?
RAS.
Probable cause.
You need to have
probable cause standard.
But
RAS is the standard for detainment. RAS is the standard for detainment. Probable cause is the standard for arrest under the Fourth Amendment, guys.
Hey man,
so
all of it's an arrest.
On his own affidavit, he admits that he arrested me on suspicion of DUI. Case closed. It's that simple, guys. But I didn't get the remedy despite these clear facial deficiencies. By the way, Beck versus Ohio states that an officer must effectuate an arrest with the information that he's aware of at the time of arrest, to the extent that would give a prudent man reasonable belief that a crime had been committed or was being committed. That's what Beck versus Ohio says, guys, and this is not meeting that standard whatsoever.
What state are you in?
I'm in California.
Okay, cool.
And then Cam, if you go down to this page right here, additional, right at the bottom of the box that he's got pulled up real quick, additional information narrative. The subject was placed under arrest for suspicion of DUI. He said it a second time. This is not, oh, I made an error in typing. I didn't type the right way. When asked, the subject stated he would not submit to any chemical testing. Guys, this couldn't be more of a home run hit right here. This is facially defective. It's just not the standard whatsoever. By the way, at the very top, I pointed out he put that the vehicle was swerving inside the lane. That, too, is fatally defective because under a Ninth Circuit case called U.S. versus Colon, the Ninth Circuit held that weaving within a lane, even to an extended degree, does not merit reasonable articulable suspicion to even effectuate a traffic stop. unless a
Which
traffic infraction or erratic movement or danger to others occurs. So that too is fatally defective to even, you didn't even have reasonable articulable suspicion to pull me over in the first place. Should have been a home run, right? I brought all this up at my evidentiary hearing, guys. And I don't have a video of the evidentiary hearing. I'm sorry. I wish I did for you guys. It would have been great. At that evidentiary hearing, I got the officer to testify that I did not refuse a field sobriety test like he put, which I believe he put that on this page. He might have put it in his arrest report. Yeah, he put in his arrest report. If you want to bring up the arrest report, Cam, it's going to be on page is it 13?
Sorry, somewhere else. Page, where are we going now?
Page 19 is the arrest report.
So coming back up, yeah.
Yeah, going back up. They put it at this arrest report will be fun to go over too. We just have 2 pages. It'll be very quick.
Sorry. Okay, we're here.
So at the very top, right, we're going to start from top to bottom. Basically, none of this shit matters, so we're going to move past it, except admonition of right towards the bottom, right there in the middle. Admonition of rights, right? Not advised. Guys, what is that? What's an admonition of rights? Is that the Miranda warnings?
That's the Miranda.
That's the Miranda. Not advised, guys. Everything is suppressed. Anything mentioned is suppressed.
See, my whole thing from this was, as my approach has been looking at it from outside, from my perspective, and just what we've seen across the board through Wisedome with other people, is the point of the unlawful command, right? Because homeboy is essentially saying, well, I didn't say you were swerving outside of the line. I said you were driving on the line.
What traffic infraction is that, Cam?
I'm not quite sure what a traffic.
No, that's the point. That's my point. That's my point. He didn't articulate an infraction, so
yeah,
that helps
so
you
it's
with
more of a care, and it's more of a caretaking stop too, because
Yeah.
that's how he was approaching it. But because he was like, I just want to make sure you're okay to drive.
Yeah.
But then you
If
made
this
a
is a
command.
safety, right?
You made a command afterwards that was like not valid. So at that point, he was like, why? And it was just like, I'm ordering you out now, which I think right there is the fruit of the poisonous tree. I think that's where everything should be suppressed. But and then
you're not wrong, Cam.
And with no admonition rights, I think that's another big play into it as well. But yeah, they violated so many. Yeah, right there. Yeah. So go ahead. Sorry.
No, from start to end. So you guys see, they didn't advise me of the Miranda warnings. Then this is where we get them, guys. The arrest report and the affidavit, they conflict. Right above the sergeant's signature, you see a couple boxes, right? The first box was so intoxicated as to be a danger to himself and others. I don't know if you guys noticed that during detainment, but I felt like I didn't need any help standing. I felt like I parked my vehicle perfectly fine, my automobile, I should say. I feel like I didn't have slurred speech. I was able to stand on my own. I didn't need help. So it's conflicting, right? And that conflicts with the coordination normal that he put on his affidavit. By the way, this arrest report's not sworn, guys. You got to be privy to that kind of stuff. Box 3 doesn't really matter. Box 6, if released immediately, would jeopardize the prosecution of the offense or offenses for which arrested on the prosecution of the offense, blah, blah, blah. Box 7 would be reasonably likely to continue the offense or offenses, or the safety of persons or property would be imminently endangered if immediately released. I mean, guys, this is just post hoc justification. This was produced 9 days after the arrest, by the way. The arrest was on the 23rd of February. The sergeant signed it 8 of March. So that is 15 days after the arrest is when the sergeant signed it, but the officer drafted this 9 days after. That's post hoc narrative, post hoc justification. That is exactly what Beck versus Ohio does not allow. That's the whole purpose for Beck versus Ohio. So this whole arrest report is inadmissible. All right, because it conflicts with the contemporaneous affidavit, the affidavit that was drawn at the time of arrest. So if you guys know people who are dealing with cases like mine, right? You got to know, you got to weigh the evidence that you've been given, and you have to know how to separate and establish, okay, what evidence is admissible, what's inadmissible, what evidence do I really need to focus on. What they're going to do is try and obfuscate you with all this shit when really we already got him on the sworn affidavit. That's the only thing that matters, is that sworn affidavit, because that's the only document that we have at the time of arrest. He didn't give any supplemental arrest report at the time of arrest. It was just the affidavit. And then if you look at the affidavit, it said attachment A. That's when he's supposed to attach, the officer is supposed to attach a document like this where he has expanded narrative, like he did right here that Cam's showing you. The officer didn't do that. Well, if the officer didn't do that, then the whole fucking affidavit calls for speculation and it's inadmissible. No judge should have signed that warrant, but they did anyways.
What's crazy is he said I asked the driver for his driver's license and he refused to provide it. He didn't refuse anything. He didn't even go towards a refusal. He asked the question. He said, "What did I do wrong?" Homie talking about, and he refused to provide it.
Yeah.
While
Well,
asking the reason for the stop. Okay. Well, just the point that you said he refused to provide it is crazy because
well,
homeboy.
to be fair, I did refuse to provide it. They just cut that out.
Oh.
I said, well, what crime did you suspect me of committing? What's the purpose of the stop? He didn't articulate. And I said, well, if you're not going to articulate what the purpose of the stop for, then at this time, at this point, I'm going to refuse to ID. But they cut it out. And that was while I was still in the car.
He talking about the driver eventually exited the vehicle and walked back, like not willingly. Like he asked for his driver's license. Then they just said they smell alcohol. And then,
Hey, Michael, I sent you some court cases on Discord that I'm using because mine was I touched the white line a couple of times.
Yeah.
Okay,
now,
so
granted, mine was a retaliatory stop, but
okay, so we got 714. Now, why don't you start coming into, I guess, speaking on some of the things that you filed now that we've got through that.
All right, guys. So that was the basis of things, right? And the first thing that I did when I took over my pro per status is I sent an affidavit, a testimonial affidavit, to the district attorney's office, certified mail on the private side, right, through certified mail. I sent it to them 3 times. They never rebutted, and they tried to say we don't do affidavits in criminal law. That's what the judge told me when I brought this up. But what did we just look at this search warrant? What does that say? Search warrant affidavit. It's weird, right? So the judges are going to tell you dumb shit just to try and obfuscate. By the way, the judges, they've shown me in so many ways that they are literally aiding the prosecution. During the evidentiary, when they asked to admit this video into evidence, by the way, this is before I did like a really deep dive into the video and started studying it, because in my mind, I'm like, dude, this case is easy as fuck. You didn't have probable cause for arrest me. You said your warrant is insufficient under every standard. It doesn't meet U.S. versus Hotel. It doesn't meet State versus Pollock. It doesn't meet, so Minty versus Arizona, Coolidge, so many different case laws on warrants, and this warrant is defective in every single aspect. So I'm thinking this is an easy case, man. The warrant suppressed. If the warrant suppressed, so's the blood. Everything's fucking done. Case dismissed. But the judges are aiding the prosecution in my case. When they asked to admit the video, my dumb ass said, yeah, sure, it's fine. Because I'm thinking, I'm already going to win because I've just got the cop to admit that he perjured his arrest warrant. And as soon as I said yes, the judge says, all right, and like slap the desk. I wish I had video of this, guys, because that's like you just displayed actions that implies bias towards the DA. You were excited that we got the video in. Anyways, after I sent that my testimonial, by the way, I titled my affidavit Testimonial of Michael Andrew Carey. I put case laws, I put, if you're going to continue to prosecute me, please ensure that the warrant meets these standards, which it don't, and you're continue to prosecute. If you don't meet these standards and you continue to prosecute me anyways, I said in my affidavit, I will prosecute and sanction you to the fullest extent of the law for malicious prosecution. So I gave them notice. It's not a threat, it's notice, right? And this is why they're fighting me so hard, because they know that I'm not fucking around. Like, if you do something wrong, I'm gonna hold you accountable. But you have to, and so I wanted to get on that, guys, because you guys mentioned the the 18 U.S.C., which is the domestic terrorism, right? I'm just gonna briefly touch base on that just to kind of correct something. He mentioned don't do that, guys, because they're gonna throw that at you. He's not wrong. But if you look at the definition of domestic terrorism, it means activities that A, involves acts dangerous to human life that are a violation of criminal laws of the United States, don't worry, appear to be intended for I, to intimidate or coerce a civilian population, not applicable. I, to influence the policy of government by intimidation or coercion. That's what they're going to use against you right there. However, you have to put the agents on notice that they're violating your rights to establish mens res or mens rea, they had the mental capacity to understand they were doing something wrong and they did it anyways, right? So they're going to use this against you, but you have to, by law, put the agents on notice that their wrongdoings are wrongdoings and they're violating your rights. Otherwise, you don't establish mens res. So be careful how you do it. Don't threaten it. Just put them on notice because you have to. If you want to go this route and litigate it in the future in federal court, right? So when I sent the affidavit, I put that notice. I also put that judicial immunity does not apply to administrative acts. It only applies to judicial acts. You got to put them on notice. I put everybody on notice. And then I attached that with all my supplemental points and authorities to my motion to suppress and motion to dismiss. And that's when we had the evidentiary hearing. We brought you guys all up to date on that stuff. The judge at the end of the evidentiary hearing, this is what he said, end quote, I'm going to find probable cause because you were argumentative, end quote.
That's crazy.
No, I shit you not.
That's
nothing
crazy.
more, nothing more, nothing less, guys.
Michael,
right?
that's a good question. Do you have the oath of office of the officer?
I have intended to get it, to acquire it by a FOIA request. I don't have it at the moment.
Okay. Under Title 5, 3331.
Yep.
Okay, you're aware of that then.
Yeah, that was in my affidavit, by the way, that I sent them.
Anybody that doesn't have that proper oath of office can be impeached.
Yeah.
So, all right.
Jack, and thank you for that. Yeah. So yeah, that's what he said immediately. I like chuckled because I was like, you can't be serious, right? And then he tried to act like I was going in dishonor by making some inappropriate statements. And he said, "What'd you just say?" And I said, "Oh, that wasn't directed at the court. That was an internal conflict that I was having in the moment. But Judge, I'm gonna be appealing that matter." Is what I told him. And then he got on a little tangent about how he thinks that I should appeal. He's confident in his blah blah blah. The judge never submitted his judicial order, his finding of fact, to a suppression motion, which in California is mandated by law under Cal Penal Code 1538.5I. It's mandated that he does that because there has to be a reviewable record for appeal. And he didn't do that. And he didn't do it intentionally because he wouldn't. You're not going to put your name and signature on an order that says I find probable cause because the defendant was argumentative. You're just not going to do that. So this is the stuff that they will do, guys, is they will violate procedure and hope that you don't know that they're supposed to do certain things. And even when they do it, they're going to hope that you don't know how to find the remedy, guys. So the only remedy for them doing that is a writ of mandamus. And you have to file it in the appeals court. It's like $20 to file a petition for writ of mandamus in the appeals court. You can do it online, at least here in California. And really you just have to establish evidence that they had a duty and an obligation as a judicial officer to do something and they didn't do it. And then the appeals court can mandate that they produce that document. But I spent the next month and a half because I had surgery on my knee like 3 days after the evidentiary hearing. So that took me out for about a month and a half. I had to ask for a continuance, which they granted. And by the way, I also filed a motion to show cause. I didn't tell you guys about that, but in the motion to show cause, I basically established that, here's the points that we established at the evidentiary hearing. And despite these deficiencies and despite the officer testifying under oath that he experienced no signs of motor function impairment whatsoever during detainment, the prosecution is
Silent suffering of a super empath in an avoidant relationship. There is a kind of pain that doesn't scream,
doesn't. This guy, Brett. What the hell? This is weird. Okay, so mute up, guys. All right, keep going, Mike.
So these documents, guys, are these are things I kind of did on my own, and this is I'm not really necessarily proud of these documents because I'm a lot better at litigating now and drafting documents, but they serve the purpose and they do what they're supposed to do. So after the evidentiary hearing, I did file a motion to show cause for the DA to basically show cause why they're still pursuing a prosecution with deficient and not effective evidence, right? They didn't respond whatsoever. And I got to that hearing, and the judge that was presiding is the same judge who threatened me the very first hearing that I had after firing my public defender when I appeared by special appearance and I asked for certain information, the nature and cause of the proceedings. I asked to be arraigned because my former public defender had waived my formal arraignment. And I also asked to establish the jurisdiction of the court. And when I mentioned jurisdiction of the court, the judge yelled at me, screamed at me, and said, this court has jurisdiction. Now get out of here and come back tomorrow, try again. And if you don't come, I'm going to issue a bench warrant for your arrest. That judge that yelled at me like that is the same judge you're going to see in a little bit where he yells at me at an objection hearing. So, and it's also the same judge that adjudicated the show cause hearing that I'm mentioning right now. That's why I wanted to put that out so you guys kind of know what these judges will do. And I don't think I think Cam was kind of shocked that these judges were doing this with me, because I remember when I was first telling him about it, he was kind of like, man, you're going up against the judges. You think the judges are...
No, I didn't believe you. I didn't believe
Yeah.
you. I didn't believe you. I was like, okay, man, I hear what you're saying, bro, but that didn't really happen, bro. Come on now.
Yeah.
And he was like, nah, bro, I'm for real. I'm like, where's the transcript? Like, you're going to have to let me hear something. Because I couldn't believe this. What, everything that we going through, I could not believe what was transpiring. And then once he did upload it, because it was a while till I got to really hear it, I was just like, fuck, bro.
Yeah.
Like, this shit's crazy. So, I mean, I don't know which one you want to hit, because I got the 14th right here. Do you want to hit anything on these ones? Because some of them you hit for.
Well, real quick, do you have the show cause hearing? You should have the show cause hearing.
Non-stop.
Which one do you think that one is?
The show cause hearings first. And we need to show the people that one. It's very short. It's like 3-4 minutes.
Okay, let's go through this. We're going to try and find it.
It's in there.
DUI holdings, outside jail, filed habeas corpus. Then we got so we got this one, it's titled, okay. This one, the document. I think I got all these already open, which is initiation of hearing. No, I don't have that one open. So I don't have the initiation. Wait. Did I just accidentally? This one? Yeah. Initiation of hearing. And then if I keep coming down, we got 714 for Retta hearing, and then show cause hearing. I think that's right here.
Here you are.
All right, 5:30:25. This one's the first one. You want to play first? Okay.
Yes. So this is going to establish you guys why I did what I did at the 7:14 minute.
Get my coffee.
Well, I never said that the court can't review the case. I said that jurisdiction hasn't lawfully been established. How's that happen? So I sent my testimony, my written testimony, 3 times to the district attorney's office, and in that testimony, I requested the nature and cause of the proceedings in writing. I never received that. And what legal authority is there for that? But that's under the 6th Amendment, sir. Oh, is it? Yeah, absolutely. You have a right to know the nature and cause of the proceedings that you want to participate in. Well, you received a complaint in this case, right? Yeah, but I don't believe that complaint was from a verified person. Okay, what else? So that's the basis of that motion to show cause, is why I have not been informed of the nature and cause of the proceedings in writing as a request. Okay, anything else? I mean, essentially, that touches that, but I do have subsequent motions. No, I'm not hearing those now. You didn't file them, they're not noticed, but as to this motion, anything else you want to add on this motion?
What, is there anything that the court's confused about? Not at all. I'm very clear. Anything else? No? Do you have anything to say in response?
Just briefly, Your Honor, Mr. Carey was pulled over in Riverside County. That was established at the 1538 hearing, as well as
Testifying.
there is cost to move forward on this case.
Yeah, thank you. Matter is submitted. There's absolutely no merit whatsoever to the motion that was filed. The defendant is present in this courtroom. He was given notice by virtue of a complaint for which he was arraigned on. That is notice. It was signed by the district attorney's office. That has been deemed more than sufficient for notice and jurisdiction in this country, not just the state. So the motion to dismiss is denied. As to the jury trial, no, sir, we're done. I made my ruling. Thank you. No, finish. You are done. No, you're done. I heard your motion. I ruled on it. Now, it's set for trial today. You filed a motion to continue. I did read that.
All right, that's it, Cam.
Did you have?
Okay.
So guys, what happened there is basically a master class in obfuscation. By the way, I wasn't prepared for this. I didn't have my transcript set up. I was doing everything on my own, and I wasn't prepared. I wasn't going into my hearings prepared. So make sure you go in prepared with like transcripts, what they may say. You got to know what are they going to try. You know, how do I respond when they try certain things, right? I wasn't prepared for the judge to basically turn my motion against me. And it's like, Judge, you're asking the wrong person the wrong questions. Why don't you ask the prosecutor how it's established jurisdiction so he can understand? Yeah, you know, there's certain things, guys, you got to really prepare for. And I wasn't really prepared for this kind of conduct by the judges. It was kind of blowing my mind. I thought that, you know, maybe I'd have a fair shot.
Michael, when you went for your arraignment and you entered a plea, that's where you give the court jurisdiction.
No, I'm aware. So that's where I fucked up at this show cause hearing, is mentioning the nature and cause of proceedings. That was my arraignment was waived and the plea was entered by my public defender, and then I fired him, right? And if I was never lawfully arraigned, I can request to be arraigned, right? You don't waive a right without having a remedy of being able to fix it, right? And so when my public defender entered that without communicating to me, and that's why I fired him, I can then reestablish that right and say, hey, I wasn't properly arraigned. I need to be properly arraigned. That never happened. But you're right, and I hear you. That established joinder. Now, the show cause, what I should have focused on was the probable cause. What we've never articulated probable cause on the record. I don't have a judicial order of the probable cause that's found by the judge. And the officer testified under oath that he experienced no signs of motor function impairment whatsoever. So I'm not clear on what evidence is being used to even establish a complaint. And you know what I should have said at that show cause hearing is if the complaint is founded on deficient and defective documents, then it's a complaint without legal force and effect. You can't just bring a complaint against somebody if it's not lawful, if it's not a lawful complaint. It has to meet certain standards. That's what I should have said at the show cause hearing. I wasn't ready for it.
Hello.
Cam, this is just the clerk stuff.
Yeah.
I don't think you need to show this one.
I wanted to get.
Just so I know, because I've had a different judge, I just need to know the judge.
Oh yeah, this is where they admit that there's no order on the record for the suppression motion.
Come in anyway.
Okay, this is 7:17. You skipped 7:14.
Oh, 7:14.
Yeah.
For 10 minutes.
And then
I'm listening
do
to
part
everything
one.
you said. I'm giving you that respect. I think I deserve the same kind of respect back. No, you're about to interrupt me again.
Yeah.
Good morning.
So quick pause, Cam, so I can tell people what's going on. All right, very brief. I went to the clerk 3 different days a week in between each time asking for the judge's order. They couldn't produce it. They said it didn't exist, and then they backtracked and said it's confidential, which that's just completely unlawful. That completely nullifies a reviewable record. So then I filed an objection to that, and this is the date that they were trying to send us to trial on this day on 7/14. And the day of the hearing, in the very beginning of the day, before my hearing at 8:30 in the morning, at about 8 o'clock, I went to the clerk and I filed some exhibits in support of my objection. And the exhibits were the affidavit and the arrest report, because I was going to use that with my objection to prove that jurisdiction probable cause doesn't exist and the court doesn't have probable cause or subject matter jurisdiction, because the the law hadn't been followed up to the point of drafting a complaint. I filed it right before the hearing and kind of caught him off guard. So you'll see I go to serve the DA after I moved it before the court. The court said the DA didn't know what was going on. So she said, yeah, we got the documents. And the judge said, oh, we just got it today. So if you got it, then he's got it, then sure, he's got the floor. And so it was some deception, right? Some trickery that I used. But what I did is I went and I handed the DA the document right then and there, because she still has to be noticed before we start diving into it. And she couldn't claim, oh, well, we never had these documents, because these documents were a part of her opposition anyways. So what I did in this video, guys, what you're going to see is I had a transcript and I followed it. And in that transcript, I kind of spent a good amount of time setting the court up with notices, basically saying, I have a right to be heard. Please do not interrupt me. Allow me to produce the evidence that I need to use for my objection. And, we can go forward afterwards, right? So that's what's going to go on here. And then the judge is going to yell at me at the very end.
And that's this video here?
That's this video here.
Okay, cool.
Good morning, Your Honor. Estella Massey from Miranda Thompson. People would request to trail to tomorrow, last day of the 24th.
And Mr. Carey, ready to trial?
So to state my appearance, I'm specially appearing, limited special appearance, for the sole purpose of addressing the objection on file. I attempted to submit a supporting document to address this, requesting oral argument under California Rule of the Court, I believe 3.306A. So I do request oral argument and presentation of the exhibit that I filed.
Go ahead.
Would you like me to do so now?
Well,
it's not before the court.
I did receive it.
He said, go ahead, trying to get me off guard.
But I'm ready to orally argue.
He's testing. Are you ready or are you not ready?
Say that again, Papa.
So when the judge did that, he said, go ahead. What he was trying to do was do what he did at the show cause hearing, right? Are you ready or are you not ready? I'm going to say go ahead and try and like make you kind of flustered. So guys, be prepared with the transcript. Cam teaches that. He definitely drafts up a transcript for you. And if you're not going in with a transcript with a lot of modifications and you're ready for certain rebuttals, certain objections, and how to, respond to those things, you're fucking yourself. So be prepared. That's what the judge tried here. Go ahead, Cam.
Yeah, for sure.
So the floor is mine. I appreciate that. So I'm going to hand this document to her so she can go over it with me.
She has it.
So I'm going to hand it anyways.
Very good.
Yep. And then, all right. So, I appear, special appearance, in persona sui juris, not pro se, and not generally under duress and coercion.
You're not to slow down.
Okay.
A little bit, Ms. Carey.
Okay. And I
helps it.
Nervous as fuck.
Court reporter has to take down what you're saying, and if you're going really fast by reading, she can't do that. I can't keep up with you either.
All right.
So, take a breath.
You got it. And I reserve all rights without waiver, including the right to challenge this court's jurisdiction, both subject matter and personal jurisdiction, for lack of probable cause.
You're going faster than before.
I can slow down, sorry. for lack of probable cause for arrest, legally sufficient warrants, and under federal precedents presented and filed in my Appendix 0 testimony of Michael Andrew Carey and my Appendix 1 cited points and authorities, and motion to suppress evidence, and motion to dismiss, and objection. I hereby declare under penalty of perjury under the laws of the United States of America that the following is true and correct and has relevance to my objections filed on the record. First and foremost, I expressly reserve my jurisdictional challenge on the record.
You're going too fast again.
Okay.
If you want to be heard, you have to speak in a way that allows us to hear you.
Okay.
Please.
First and foremost, I expressly reserve my jurisdictional challenge on the record and object to any further proceedings until this threshold issue is properly adjudicated. Proceeding to trial without resolving jurisdiction constitutes a fundamental due process violation. I intend to state my objectionable challenges here and now for the record. I advise the court that I am not an attorney, and due to multitudes of prosecutorial misconduct and complete failure to allow fair process, this may take some time for me to go over and get through. So to ensure brevity, please allow my oral defense to occur unimpeded. All statements hereinafter and the pleadings I refer to are filed on the court record in my defense, and proper process has occurred to all parties involved. I request the court honor my right to be heard in a meaningful way and do not interrupt or interfere with my oral defense, despite the length, which I assure the court in good faith I have attempted to make as brief as possible. I further object to this court's continued presumption of agency on my behalf. For the record, I demand judicial notice of the testimony of Michael Andrew Carey, Appendix 0.3, which, apologies, I have with point 3, which reads, this document and all of the pleadings and paperwork filed for case number SWM 2402170 should be entered into the public record and the private record and the court record, and then entered into evidence at the earliest possible time. I hereby put all people and persons on legal and lawful notice that I do now and forevermore void and terminate all past and present powers of attorney according to Corpus Juris Secundum, Volume 7, Attorney and Client Section 76(4). The attorney's duty to the court is superior to the attorney's duty to a client, since the private duty must yield to the public duty. With that in mind, I will hold court in persona propria sui juris, and I let all involved in this controversy know that I do not consent to these proceedings.
There's not a single person who's sitting here who consents, but go ahead.
It's on the record, so you don't need to consent. Thank you. Let it be clear, I did not request permission from this court, the DA, or the Office of Public Defenders, or any associated party not defined herein to terminate powers of attorney relationships. This was a unilateral declaration of agency, termination, and lawful standing as one of the people, executed under lawful authority pursuant to 28 U.S.C. 1746, titled Unsworn Declarations under penalty of perjury, not an offer requiring acceptance. All documented communications were served as lawful notice, not as pleadings subject to approval. They remain unrebutted point by point, and therefore stand as truth in fact and commerce under the maxims of commercial law. Silence equates to acceptance, dismissal equates to dishonor, and obstruction equates to liability. That's notice to all parties and persons present today. Now we must address my objection stated for today's docket on the record. I'm going to state this again, it's in my paperwork. I move all of my...
I've read it.
Okay.
Feel free to repeat if you think it's necessary.
I appreciate that input. Thank you, Judge. Appreciate it. I appreciate it if you remain impartial. Okay.
I am.
That sounded
You're not worried
opinionated.
about that.
It sounded opinionated, Judge.
Please proceed.
All right, thank you. I move all of my pleadings, filings, exhibits, and documents involved in case SWM 240-2170 into the court record, the public record, and into evidence immediately, if not done so already, as demanded in Appendix 0, Supra, Point 3, Supra, which I just read. I'll let her catch up. I continue my defense under point 24 of that document, which states, you have 3 days from receipt of this affidavit to respond on a point-by-point basis via sworn affidavit under full commercial liability, signing under penalty of perjury that the facts contained therein are true, correct, complete, and not misleading. Mere declarations and statements and complaints and the like are insufficient response, are in insufficient response, and void and a complete nullity. If an extension of time is needed to properly answer, please request such in writing and submitted on the record. Failure to respond will be deemed nil dicet, tacit acquiescence, and constitutes agreement with the facts stated within this affidavit, et al., aka testimony, et al., and as an acceptance of liability and benefits. Prosecutors, take heed, for I oppose your legal manipulated cause, for I am a non-combatant and a man of peace and a peaceful inhabitant. And then I'll continue to point 25. I demand you provide me with a certificate of trust which allows you to act as administrator or beneficiary and which obligates me as trustee in said business venture trust. Either you are a civil officer of the United States and have such, or you shall be seen as an interloper without jurisdiction and without authority to proceed. I also demand you provide me with a copy of your oath of office in accordance with 5 U.S.C. 3332. And then I'm going to continue. Point 26. I have a right to equal access to justice in accordance with U.S. v. Lang 792 F2D 1235 4th Circuit 1986. I demand the rules and procedures of the statutory court. I also demand a true and correct certified copy of the complaint and file against me. You may not bill me for any such records and must bear the cost to supply me with any and all transcripts, audio, and video recordings of each and every court hearing proceeding, communication, and the like. And I'll note that I was assigned a public defender at the very beginning, so my status as indigent is already approved by the court. So I request that the court accept that and provide me with the transcripts from today and past hearings as requested. I might not have to read that one. I respectfully demand you provide me the nature and cause as well as the jurisdiction of this court and these proceedings in writing. You have a duty to inform me of this, or it is a violation of due process of law under the Sixth Amendment. That's bracketed, under the Sixth Amendment bracketed. If only licensed attorneys have the true information, then I, the accused in this criminal action against me, have asked you to divulge the nature and cause of the accusations upon the authority of the Sixth Amendment, and that you have failed in your duty to inform me of the nature and cause of the action. Furthermore, I demand it be entered into the court record and public record that this court intends to bring criminal actions against me under a secret jurisdiction, which is known only to licensed attorneys, failure to inform me properly in writing will result in me bringing civil and criminal proceedings against you for malicious prosecution.
I'll tell you what, Mr. Carey, you've been talking literally nonstop for 10 minutes, and I've been timing it. So I'm going to cut you off.
Okay.
Because you told everything you're telling me, you've already put in filings. These are things we already talked about previously.
Fair.
One thing that did catch my attention is you seem to be suggesting you never received the complaint. I don't think that's true, but we're going to give you a copy now.
Okay. I can address that.
Thank you.
So I received.
Now it's my turn. Thank you. Look,
I get interrupted.
everything that Mr. Carey has said has essentially been ruled upon previously. The court has established jurisdiction by virtue of the alleged crime taking place in Riverside County.
Objection. For the record, I object, sir. You didn't.
My turn.
But it's not. I wasn't
my
finished.
Turn.
You interrupted me, sir.
It's my turn now.
Is it my hearing or is it your hearing, sir? Do I have a right to be heard?
Ladies and gentlemen, we're in recess.
Boom.
Wow.
Boom.
Wow.
The demon came out.
The demon came out, guys. So a lot of what I did in the beginning there was kind of redundant. I didn't need to do it.
Everything that Mr. Carey has said has essentially been ruled upon previously.
Hey,
Court has established jurisdiction by virtue of the alleged crime taking place in Riverside County.
Objection. For the record, I object, sir. You
my
didn't.
turn.
But it's not. I wasn't
my
finished.
turn.
You interrupted me, sir.
It's my turn now.
Is it my hearing or is it your hearing, sir? Do I have a right to be heard?
Ladies and gentlemen, we're in recess.
So when I asked that question, guys, he did not answer. Yes, you have a right to be heard. He didn't answer. What he did is he said, court's in recess, and ran off the bench. The reason he didn't answer is because he would have put himself in liability if he answered. If he says, yes, you have a right to be heard, well, you just screamed at me, yelled at me, and interrupted me. If you answered any other way, you're taking liability. So that's what he did there.
He went recess and took a bong hit is what he did.
He went
to go take a Xanax real quick.
Yeah, right?
I gotta calm down. Look at that. Damn, bro, chill. That was crazy, dude. I can't believe he yelled at you like that.
And that wasn't the first time, guys. The very first hearing I represented myself and I put a special appearance hearing, he did the exact same thing, and he threatened me with arrest. So I knew this guy was on bullshit. And that's the only reason I read everything that you heard right there, because a lot of that's redundant. I didn't need to read it because it's on the record, but I read it in court anyways. And I also said, in the beginning, I put him on notice to please honor my right to be heard without interjecting. And I said, in the maxims of commercial law, obstruction equates to liability, right? So by doing that, I put him on notice that if he does certain things, he's taking liability on. And then there he went and he did it anyways. As soon as I brought up malicious prosecution, which by the way is ballsy as fuck of me, but I didn't care at this point because I'm like, I know what you guys are doing and I can prove it, and I will prove it.
Counsel.
So this is when he comes back from recess, correct?
Yes.
Carey, give everybody a chance to come back in.
This explains why I was nervous at the beginning.
Back on the record with Mr. Carey and Ms. Matthews. So Mr. Carey, let me kind of lay it out for you. I'm going to provide you the same opportunity I provide everybody. Full opportunity to be heard within reason. And I regret and I apologize for raising my voice, but you interrupted me. I let you speak nonstop for over 10
You interrupted me? What is he talking about, bro?
Deflection, bro.
Like, what is going on here, my guy? I want to let's just take
the guy such a turd. I thought he was going to flush himself down the toilet when he left.
Say that again, bro.
The guy's such a turd. I thought he was going to flush himself down the toilet when he went to the bathroom.
full opportunity to be heard within reason. And I regret and I apologize for raising my voice, but you interrupted me.
You interrupted me. Fucking child.
I regret and I apologize. Well, that's too late. It's too late, buddy.
Yep.
Sorry. You can regret and apologize all you want and make an
While you
excuse that it's
recuse
because
yourself.
I interrupted you while I was fucking speaking. I think it's really the opposite here. And you just mad that I am again coming forth with. I mean, these people don't get it, man. Say, man, they don't have people stand up. And so when they, people are standing up because again, the lawyers just kind of acquiesce to the authority of the judge as a respect thing, right? Because they're all in this clique, they're all in this branch. They don't want to, you know, everybody knows that it's all about tit for tat and favors and how can you help me here? And nobody wants to ruin that, right?
Well, Michael called him out on that and called out the statutes that says that the attorney's got the loyalty to the court.
Yep.
That's why he's defending himself. So that was great to pull that on the record. I thought that was beautiful.
You have to put that kind of stuff on the record, guys, because they're gonna challenge you. What authority? What authority are you using? What authority are you citing? You gotta put the authorities on the record.
Is this a court of record? Are you in a circuit court
Oh
or
yeah,
something higher?
oh yeah, he's in a court of record. That's
No,
why they
no,
told him to kept
Alright.
slowing down because
This is the lowest court, but there is a court recorder, so there it is a court of record.
Did the court recorder record that time when he yelled?
I don't know. They won't give me transcripts.
Wow.
Bro, we can use that. We can use that.
I'm telling you, bro, he just mashed it out on the judge.
Persuasive authority. It's my turn.
What is within reason to be heard, though? I mean,
Exactly.
you're putting limitations on my defense.
Yeah, 100%. It's vague and ambiguous, guys. And under the judicial canon 7B, I think it's 3B7. I'll bring it up for you guys so you guys don't have to be bugged about it. It says that.
Gentlemen, one recess. Crime taking place in Riverside County.
Objection. For the record, I object, sir. You didn't. But it's not. I wasn't finished. You interrupted me, sir.
But it's not.
All right. Brief pause.
Record, I object, sir. You didn't. But it's not. I wasn't finished. You
Brief pause. California, and guys, I knew these canons. Study your canons, your judicial canons for your state before you go into these hearings, so you know what they have to do. Once you know their obligations to you, you know what to expect. And I did this intentionally. Everything I did, putting them on record, reading the record intentionally, was I wanted to see what this judge does. How's he going to act? Because I'm recording all this shit, and I'm building a record right now because I know I'm suing these people, right? Judicial Canon 3B7, a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the full right to be heard according to the law, unless otherwise authorized by law. A judge shall not independently investigate facts in a proceeding and shall consider only the evidence presented or facts that may be properly judicially noticed. Now, guys, I'm going to focus on that real quick. Hasn't he been saying that hasn't he been weighing the evidence, saying that I've received a complaint and that establishes jurisdiction? Hasn't he been doing that on his own accord without being prompted by the DA? Yes, he has. Yep. Yes, he has. Now, this prohibition extends to information available in all media, including electronic. A judge shall not initiate, permit, or consider ex parte communications, blah, blah, blah. And then there's some exceptions, right? The exceptions. There's one that's important. Under the advisory committee commentary, judge presiding over matter. Shit, I wish I had this more at a.
Can you do a search for it? Control Alt F and then put in the word you're looking for.
Let me try.
Control Alt F.
Okay. Let's see. This fucking word. Let's see if this helps. Okay. Here it is, under the advisory committee, Canon 3B12, while a judge plays an important role in overseeing efforts to resolve disputes, including conducting settlement discussions, a judge should be careful that efforts to resolve disputes do not undermine any party's right to be heard according to the law, guys. That's right there. That's right there. The judge should keep in mind the effect that the judge's participation in dispute resolution efforts, which I'm having a oral argument on my objection, which is a dispute resolution effort, right? At least to build a record, may have on the judge's impartiality or the appearance of impartiality. If the case remains with the judge for trial after resolution, efforts are unsuccessful. Accordingly, a judge may wish to consider whether, one, the parties of their counsel have requested or objected to the participation by the trial judge in such discussions. The parties and their counsel are relatively sophisticated in legal matters or the particular legal issues involved in the case. A party is a party is unrepresented. That's right there. Boom. 3, a party is unrepresented. So the judge needs to be aware of these certain things, and he cannot undermine a person's right to be heard. And then there's a note 3, if a party is unrepresented. Guys, you got to know these canons, and you got to know what these judges are doing, because I used this in my my petition for writ of habeas corpus, because this same exact judge that just yelled at me, guys, he ordered me to come back in 3 days, and then on that 3rd day, he immediately held me in contempt of court.
Okay, now check it too. Another way to bring these maxims and doctrines in is to bring in judicial notice, y'all.
Yeah.
Right, and you can do that in conjunction with an affidavit too, right? If you're bringing in an affidavit of fact, trying to bring in court of equity, or the fundamental equity of getting what you deserve. But yeah, as far as judicial notice is concerned, that's a good plus to have up under you, because once you bring it in, it's known that that's something, again, that you're invoking. And that invocation has to be respected and discussed if there's any issues with that. So are we doing the second part of this 714 or no?
That's up to you. If we did, we could do the last part to expedite it. I know this is kind of going long and people have days to get to and stuff.
Oh, bro, ain't nobody tripping if you not tripping.
Ain't nobody tripping, dog.
More time. We're enjoying every bit of this.
Yeah, this is what we're here for, bro. Yeah, no, we're chilling, bro.
Tomorrow, Your Honor. Thank you.
For the record, I request more time.
You haven't filed a motion to continue. You're very, very firm on making sure process is followed.
And it hasn't been, and you don't care.
Shouting over him again because he's interrupting. Under 1050 of the penal code, you need to file your motion to continue at least 2 days prior to the hearing. You didn't do any of that.
This isn't a motion to continue.
Trail this case until Thursday, July 17th at 8:30.
3 days later.
Mr. Carey's ordered to return Thursday, July 17th at 8:30 for trial. 10th and last day is July 24th. Time has been 4 days, and I'm in recess.
All right, so what we'll notice is all the way back in July was when they was pushing for trial.
Yep.
Last year. Okay,
Yep.
He said 7/17, y'all.
Yep.
This shit's still going.
Yeah.
You understand that? This
Yeah.
shit's still going, y'all.
So what happened is 7/17 he held me in contempt.
Oh, I'm not even sharing right now. Damn, y'all didn't hear that properly. Did y'all hear that okay or no? Y'all didn't.
Yeah, that sounded fine.
Oh, okay.
Yeah, we heard it already.
For the record, Judge, you left the bench already, so you are already in dishonor.
gentlemen, we are
For the
recessed.
record,
Please step
this
outside
matter
to the
should be
hallway.
dismissed
We're
with prejudice. I give notice that I intend to file a writ of prohibition.
Step outside.
I don't care. I don't care.
Step outside. We're in recess.
What I'm not going to do is be denied my right to be
Step
heard.
outside. We're in recess.
My boy was a go-getter. He ain't playing with him.
I already did, Joe. Joe, I recommend you print out a copy of the codes for contempt of court so you can have them on hand before going to the court. Yeah.
Wait, you don't know about Joe?
No, I don't know Joe yet.
Oh, Joe just beat a UPL against a judge that gave him a contempt, and his wife and his son. They all got arrested, and he spent like 16 days in jail. He got like a $30 million lawsuit. He just won. Yeah, he went to trial and won that thing.
Well, yeah, I got my trial for the UPL charge, so that's dismissed, found not guilty. So my son and my wife is now fighting the contempt charges that were allegedly misbehavior. And so anyway, there's like 5 elements of at least in Virginia of what for the grounds of contempt charges. So anyway, my point was more just general for the team, Mike. It's if you guys are going to court, you should print out, have a copy of the contempt charges that court can at least claim. That way you can refer to them right then and there, and then appeal those contempt charges immediately. You can actually appeal those contempt charges. If they find you contempt of court for whatever reason, you can appeal those right then and there that day and take it to a higher court to be heard and challenge those charges. And
without
usually
going to jail, Joe?
if you appeal, they're gonna listen. They're gonna do what they're gonna do, right?
Yeah.
But you do have the right to appeal a contempt charge and be brought to a higher judge that day. Whether that happens or not is another story. But so I'll give you an example for Erin's matter. She was found in contempt of misbehavior, which requires the interruption of the administration of justice, which she wasn't doing. But had she known that she could appeal that right then and there, she would be taken to a circuit court judge to hear the contempt charge, and then they would have to show cause on how she interrupted the administration of justice. So my point, though, is all this is be prepared to be held in contempt, have those codes on hand at court, so that if they do say that you're being held in contempt of court, you can ask them some questions. Articulate exactly what it is that you're claiming for contempt of court to be charged. So that's really all I wanted to say about that.
No, that's
You're
very,
entitled to a hearing right away.
very wise. Yeah, so I was held direct contempt. So it was immediate. It was like an ambush. I didn't get to come back and have a full trial. It was direct contempt. It was an ambush. I also heard that you can challenge the contempt because it's a separate charge. So you can challenge the jurisdiction appropriately and conditionally accept the charges as long as they prove jurisdiction, right? Which they can't do. I don't know how anyone feels about that. I don't know anybody who's done it and been successful, but I learned afterwards you can say, well, I conditionally accept the contempt charges so long as you provide me the signed document, the signed contract that where I agreed to follow whatever the court's order is that I disobeyed. Stuff like that. Now I don't know if you guys want to even consider that, but
I was under the impression that contempt can only be filed on an officer of the court.
No, yeah, well that's why I said you can challenge the jurisdiction and conditionally accept. Because if you conditionally accept, you're now moving that judge into dishonor. He either takes liability, right? Because the whole point of court is to avoid conflict. So the judge either accepts liability and holds you in contempt, to which now he's liable because you tried to resolve the matter by conditionally accepting and saying, just please show me the signed contract where I agreed to follow any rules of the court that it deems that I've violated, and then specifically specify what rules I violated, and I'll conditionally accept it. He then takes liability. So I've been told. Now I haven't had this practice. So, but yeah, in order to hold somebody in direct contempt immediately, right then and there, the act has to occur within the judge's presence. So my judge basically was trying to say that I interrupted the court. I failed to follow lawful orders. And if you guys want to see the contempt order, I have it. We could look at it. It's basically a 1-page order, and it's dog shit. It looks like my daughter drafted it. I mean, it's just a bunch of conclusory language. There's no specification whatsoever. There's no transcript inserts, no reference to any evidentiary record. It's basically it's the judge's monologue of alleged misconduct, basically. So that's why I had to petition for habeas corpus to vacate that one.
Did that get acted on?
No, it hasn't been acted on yet. It's still in the process. So guys, with my situation, I'm clearly going up against the whole system, and they know it. They know, like, oh, this guy knows everything and he's trying to bring us down. And so when I did petition the appeals court, they summarily denied it. The first time they denied it, they construed it as a writ of prohibition, and I didn't include the proper evidentiary record for that, which would, for the evidentiary record for a prohibition would be that the judge never filed a judicial order for the 1538.5 suppression motion. That is good cause to prohibit any further proceedings until that document is produced. I didn't include that originally, so they construed it, even though I filed it as a joint for prohibition and habeas corpus. The grounds of prohibition in my initial was, hey, I'm not able to represent myself due to the subject contempt order. So we need to restrain, right? And so they construed it as prohibition and didn't consider the habeas corpus, which is the superior writ, and so they denied it, right? So then I refiled and corrected it, and then they denied it again, saying that it was repetitive and frivolous and threatened me with sanctions. So that's where, in the beginning, I told you I went to the Supreme Court of California with an original petition, and I've spent the last 7 months really refining my skills on how I draft my documents. And I feel really good about the original petition that I submitted to the California Supreme Court because I did it for all three, right? Prohibition, habeas corpus, and mandamus, and I identified the grounds for each relief requested, and then I identified the evidentiary record, which I attached as exhibits for each identified relief. And within a day, the Supreme Court remanded it back down to the appeals court with instructions because once the appeals court denies something summarily and they don't adjudicate the merits, you can't even file a motion to reconsider. You can't even file a petition for reconsideration because they didn't adjudicate the merits. They just summarily denied it. So that's what they'll do at the appeals level if they're trying to like really fuck with you, you know? So then the next step would be to go to the next court up, which I did, and then they remanded it down, and that happened about 12 days ago, I want to say, 10 days ago. No, about 12 days ago, on the 19th of this month. And then I
Hey, Michael.
called, yeah, the
Hold on,
remand.
well, wait. That right there is kind of big, bro. I just want to say congratulations on that. I think you successfully did that, and I'm very happy to see that happen. That you got a remand back down to give them some instructions to say, "Hey, go get them," because that's a big step, right?
Yeah.
People don't be taking that next step to the higher courts and then getting remedy on the higher courts. They just kind of acquiesce and stay down low. And you shot high, bro, and you made that shit pop off. And to be honest with you, this was a point of where you had already been denied on some other on your shit to the Supreme Court, right? So to get a denial yet come back or onto the lower court, not Supreme Court,
The
but on
appeal
the
court.
appeal court, and then to come back again and get higher, that's amazing, bro. And I don't know if everybody wants to unmute and say congratulations on that. That's a big accomplishment, bro.
That's awesome, brother.
Congratulations.
Congratulations,
Thank you.
man.
And it was
That's awesome.
it's caveat, it was three times at the
I
appeals
have
court.
I
Three
have a
times at the
question for
appeals
you,
court.
Michael.
That's a
What's
huge
up?
win.
Big
Have
time.
you thought about filing a counterclaim and just moving the whole thing to federal court?
That's a good question. I've thought about it, yes, but I don't have enough knowledge. I'm still pretty new in this shit, and I've been I'm a single dad, guys. I work full time, so I study when I can. But I've only been doing this for about a year and a half, 2 years, and within that time, I've been a single dad full time and working. So like, I really have limited time to study. And then one thing I noticed.
Kudos, brother.
One thing I noticed, guys, is in this field is like this is why I'm telling you guys that this wisedome that's going on is so fucking important because it really takes a community, because you get a lot further when you have structure and guidance. Like I feel like a totally different litigant now as opposed to 7-8 months ago when I was going through this shit. Now I'm like
That's because when you're working by yourself, you're just speaking out into the ether. When you're freaking working in a wisedome, you have a wall to bounce stuff off of.
yes.
You can get some input, and and it just feels better. Feels a little more solid, like you're on the ground rather than out in space, just talking to the air.
You know what it makes me think of? It makes me think of like when you concentrate the sun rays.
Yeah.
You know what I'm saying? You just fine tune it all the way to that point, you know?
Yep.
So
Look at this little wisedomian coming up.
So Ralph, I believe, is the one that addressed that. Yeah, I definitely have thought about filing a counterclaim and moving it to federal court, but I don't really have much to work with to do that. Like they didn't submit in a order for the suppression hearing. They won't give me transcripts. They said if I want transcripts, I got to pay like a absorbent amount of money, and then it could take weeks to produce them. You see what I'm saying? So it's like to move it to federal court without transcripts. I feel like would be hard because you don't have anything for them to work with.
Well, they're demanding what kind of monies, because we're not supposed to be using Federal Reserve military scripts.
Yeah.
And under the House Joint Resolution 192 of 1933 and Public
Yep.
Law 7310 and the
I'll be right back.
Clause, you know what I mean? They can't demand anything, and you could just give them a negotiable instrument.
Yeah. So it's a private court recorder, guys. By the way, in my case in California, the court recorder is not necessarily a part of the court. She's a private person with her own practice that the court contracts with her. So that's how they get around that because she's a private business providing a service to the court.
She's a subcontractor.
Yeah, she's a subcontractor. So it's like she can request that I charge her or that she can charge me because it's a service that she's providing. Does that make sense? It's not the court that's providing that service. It's a separate subcontractor.
Yeah.
And
Well,
they
yeah, but the court is contracting that through her, and
Yeah.
so
Yeah.
because you're at a court of record, they still need to provide that. Now there is a fee for that, so there's now how you offset that fee is really what I think Ralph was talking about, where you can use a negotiable instrument. I haven't been successful with that. I've never actually tried to use a negotiable instrument. It's just a lot easier and quicker to send some payment to deal with that.
Okay.
So but yeah, I've also hired a court reporter myself for some other matters, and it was like $230 or something like that. And so yeah, it could get expensive doing it that way.
Yeah. Someone mentioned a W-2 fee waiver. No, I don't have a W-2 fee waiver. I make too much. So the issue is I do make too much to technically be indigent, but the court forced a public defender on me because they were what they were initially trying to do is like, hey, let's get this guy to just take a plea and we'll reduce it to wet and reckless or something and brush it under the rug. And my public defender was yeah, it's like you never should have brought these charges anyways because you don't have any. And I know you lied about the blood. I can't prove it yet, but I know you lied about the blood. And laboratories have been known. There's a history that laboratories falsify blood results. So I know it happens. And I know it happened with my case because I was the fucking DD. I was tired, but I wasn't drunk. It was late at night. I might have been a little sleepy, but I wasn't drunk. I wasn't intoxicated. And then they did the blood extraction at 4:30 when the arrest was at 2:30, which it wasn't at 2:30. It was probably at like 3, or 3:15 or 3:30. But either way, I hadn't
is if anybody is borderline diabetic, it changes your blood and your breathalyzer. So keep that in mind.
Yeah. But so I mean, there had been hours that have passed when they did extract my blood, and it's just super it's scientifically and factually impossible for there to have been 0.09 BAC. I mean, I have no doubt that my blood probably came back 0, and they're just like, "Fuck, this officer is kind of fucked. He's got no leg to stand on. He lied about his sergeant. He did this. He did that. He lost his qualified immunity once he lied about his sergeant and terminated the field sobriety test because that's against his policy.
Him to the Brady list.
Yeah. So wait, what was that, Ralph, about the Brady list?
Do a check on him to see if he's on the Brady list, and if not, add him because he lied under testimony.
I did add him on my exhibits list, not Brady list. Is it different? A Brady list and exhibits list?
The list is when they're caught lying and or being deceptive, they can never testify.
Okay.
Apparently the deputy that arrested me, he was a highway patrol and he was dirty. So
There's a website already out there to see if someone's on the Brady list. I forget what website.
Yeah,
it
there's.
is. You can just type it in easily and find it. I did.
Yep. Okay, let's see.
I recall the Brandon Beltran matter. Good morning, I'm Royal Stark on behalf of Mr. Beltran. Mr. Beltran is not present. No, his mother's present. Mom has indicated to me that he has. Okay. His mother is present. Is there an agreement as to what date and magnitude? I believe the DHS the officers and the that means that will sometime later today.
Can I get more clarification? How long?
I'm here till 4:30.
Do I need to wait in the courtroom? Can I wait outside?
Okay, that's just the initiation of the
Yep.
hearing in and of
And
itself.
he just said, hang around. I said, how long? He said, I'm here till 3:30 or 4 or some shit. And I'm like, well, that doesn't fucking clarify anything, but all right.
Okay, so then we have the contempt.
And for CDL, I am not one of their trial attorneys, so it would have to be assigned to a trial attorney. I think an attorney would help him be able to get his points across. He hasn't let me explain that to him, but we studied this for a long time.
Yeah, so I guess what I would ask you, Ms. Johnson, is this.
What, you want to say something? Y'all can hear that okay or no?
Yeah.
Yeah, sounds fine.
Yeah.
I'm going to do it on VL. VLC though. Now I can't find VLC.
Fighting rulings. And so the only thing we can go forward at this time was the court was revoking his pro per status as plain counsel. And I appreciate you being brought in to this case today about 2:10 p.m. I'm sure you just gave a notice earlier today from the panel.
Yes.
Okay. And we had a chance to try to talk to Mr. Carey.
I tried.
And
I introduced myself and he said, stop, right?
Absolutely.
Stop. And then I said, well, I'm a private attorney, but I'm here to help you. Stop. I don't want to talk to you.
Fair enough. And so I appreciate and believe you empathize with the position you're in. One thing else I did is Mr. Carey, which has been his custom, yesterday filed a series of what I'll label motions, but they're really not. A lot of them are objections. A lot of them are, quite frankly, I can't even comprehend what he's saying. Within them, I did read them thoroughly earlier this morning before I took the bench. There are a couple, I don't want to call them nuggets, I might be overstating it, the things that may need to be addressed substantively down the road, if not today, probably not today, because you haven't had a chance to look at them. The case is set for trial today. This is the master calendar, as you know. People have announced ready. Matter's been trailing. There's been no courtrooms available. One of the things that Mr. Carey points out in the bulk of documents he filed yesterday was a claim with regards to doctored body-worn camera video. People haven't responded. I don't expect a response today, but him wanting time to investigate that. So, one rule I'm going to lay down, which I tried to make it clear earlier this morning when Mr. Carey was representing himself, and that is we're going to proceed in an orderly fashion. His conduct at this point has disrupted the proceedings to where we cannot proceed. We are paralyzed because of his behavior and his conduct, and I'm not going to allow that to happen. And that's why I revoked his pro per status. Those orders still stand. Mr. Carey, that he's on notice that further he's been ordered not to disrupt the proceedings, not to interrupt, not to attempt to address the court out of line. Should he do so, he's on notice that the court can hold him in contempt, or at least set an OSC regarding contempt, which could result in up to 5 days in county jail. I haven't gone there yet, but I want the record crystal clear to know that's where we are, okay? So, and Ms. Thompson, I know you're still ready for trial. Ms. Thompson, I'm sure you are not going to be ready.
And for CDL, I am not one of their trial attorneys,
Okay.
so it would have to be assigned to a trial attorney. I think an attorney would help him be able to get his points. Let me explain that to him, but we studied this for a long time.
Yeah, so I guess what I'd ask you, Ms. Johnson, is this, Mr. Carey, within his pleadings, implicitly is a request to postpone the case.
Okay.
Ms. Thompson, I don't think you're going to have a big
I don't have a
objection to
problem.
that.
That's what you want.
No,
No what?
that's not what I want.
What is it you want?
I would like.
Could I have a moment?
Yeah.
No, it's simple. I'm not asking your permission.
No, to talk to me.
Okay, with respect, I simply reserve my right to rebut and overturn his decision.
Of what?
His ruling.
To rebut your
appointment of counsel and allow me to rebut other rulings.
Ms. Johnson, this is not going to be productive. I want you to be able to consult with him and have him consult with you, or for other trial lawyers to be in a private setting. This is a public courthouse. There's lots of people in here right now.
So,
and plus it's disruptive.
Yeah,
So, Gary, someone can talk with your lawyer. So, I assume you're going to want a little time for the panel to get a trial lawyer on the case, who will then have time to consult with Mr. Carey and come back.
Yes.
And to be honest, my intention is not to set a trial ratings conference. There's no point to that. If there's a notice motion by counsel, not Mr. Carey, he has a lawyer now, by counsel only, it can be scheduled, whether it's here or in 104, at the appropriate time. Ms. Thompson, I don't want to cut you off, but I want to give you an opportunity to get any comment on what I'm supposed to do.
I need to ask you something.
Okay.
May I have a private word with my...
No, you want to go outside and talk? Yeah,
Yes.
outside.
Point of order. I'm just.
No, Mr. Carey,
It's out of order now.
you are, what I'm going to do is I'm going to step off the bench, and you can talk and find out in the hallway, and when you're done, I'll be happy to come back out and call the case, okay?
Anything he says which overturns his rule if it conflicts. The right to waive counsel is guaranteed by the Constitution. It must be scrupulously honored. That is out of Adams versus United States. I'm not done. The Constitution does not force a lawyer upon a defendant. A defendant in a criminal trial has the right to self-representation, and it is violated when a court forces counsel upon him. Ferretta at 819-821. Asking clarifying questions to comprehend what the court is trying to convey, such as attempting to object to statements or rulings of it to preserve or to rebut, and later on in the proceeding, when given the opportunity, which he did not give me the opportunity despite my objections, is preserved and does not constitute threats of contempt of court. And I will get into if he's threatening me with civil contempt or criminal contempt when we get back in there. Because I know my rights, I know the law, I am competent to testify and defend myself. And I'm not here for trial, I am here to submit my documents, which is on the ex parte, and move these documents into the matter to dismiss this matter immediately.
That's not how it works. If they can't accept the way you wrote it, they need an attorney to write the motions for you. Why aren't you allowing someone who knows how to do it to do it?
Because it's all in my pleadings, and he knows it very well. Under Corpus Juris Secundum Volume 76, Section 4, attorney-client privileges, an attorney's duty is superior to the court than his duty to the client, because his public duty exceeds the private duty. Secondly, jurisdictional challenges are waived the second you have an appointed attorney. Waived. I will not accept appointment and waive jurisdictional challenges when I have jurisdictional challenges before the court that have never been proven, and I have it on record that it has never been proven. And jurisdiction must be proven. And here we go.
You're a constitutional.
No, first of all, I know that with disrespect, and I put you in dishonor. You are no longer available or authorized to even consider representing me.
I'm trying to help you.
If you want to help me, you allow me to finish my rebuttal and express why the court has not made the prosecution prove jurisdiction. And I can prove it. I can prove it. I don't need to explain myself.
And then when the judge denies it, hasn't that's already been litigated?
No, because I've not done this, and I'm going to overturn that ruling as well based on superior precedent. I will overturn that ruling as well. Everything that I did on Monday was to set the foundation to protect my rights and preserve my honor, and so that he would not continue to obfuscate and to run fame as if whatever I'm talking about is not competent and not law, and all these other things. Now I understand that the court does not get pro se litigants that take their defense seriously. However, I know beyond a reasonable doubt that all these charges are false, erroneous, fabricated. They lie about the blood results.
So you need a trial.
No, I will prove no, because I'm going to get this done, and then I'll prove it in federal court.
It's done in trial, not while you're telling the judge they don't have jurisdiction.
So the jurisdiction must be proven. It's not been proven. I'm going to prove that it's not been proven, and then because I can prove tangibly it's not been proven, and then he will have to move in dishonor and dismiss himself. And I have my defense set out. Yes, and just so you know, so it's on the record, I've already filed a writ of prohibition. I'm only preserving my right to amend that writ under 1983 actions because he keeps obfuscating and obstructing me. And my right to rebut his rulings are absolute. And my due process rights are absolute. And my right to be heard is absolute. And not heard in a meaningful way. He cannot dictate what meaningful consists of. He cannot dictate what meaningful is described in his opinion, because just a mere opinion of that would imply bias. If the third party disinterested, guess what? If the third party trier of fact dictates what is proper and what's not proper before I get to finish my process, that's bias and prejudice. And I don't care if you agree, I don't care if he agrees, we will litigate in federal court. Because I already have to bring a prohibition, I'm reserving it to amend for 1983 actions. And it is all on the record. And you weren't here on Monday when he abandoned.
They just ordered someone to come in this afternoon.
I understand this isn't your fault. You weren't here on Monday.
You're right.
I'm not trying to attack you, but you are going to help me by going in there and saying he's competent to testify.
I can't say you're competent
Okay.
because you're not understanding the procedures.
Okay.
You're saying things that have been litigated before,
Okay.
in this case and in others, that this court does have jurisdiction.
And
So if he finds you
rulings-
incompetent,
And rulings can be overturned, yes or no? A judge's ruling can be overturned by superseding precedent, yes or no? Under the supremacy clause of the United
it's
States
with a
Constitution.
proper appeal,
With-
but you
I don't need to
haven't.
appeal because we have a trial and he hasn't, we haven't.
You can appeal or
No, everything, okay, well, I can overturn his rulings as well with restatement of judgment by telling him your judgment's erroneous because an erroneous judgment is null and void, period. So if I can prove that his judgment is erroneous based on superior precedent, then he has to overturn those rulings. And if he doesn't, it's a violation of due process, it's obstruction of justice, and it's in dishonor. A judge cannot dictate these things. And Loper Bright Enterprises versus Gina Raimondo, I'm sure if you read it out of 2024, the Chevron deference was overturned. All right?
No, I don't know that.
Okay, let me tell you, I don't study just state law. I've done nothing but study law for a year and a half because I was wrongfully arrested and they lied about my fucking blood and they pulled me in and they dragged me here for a year and a half on bullshit charges that do not exist. And I can prove they don't exist.
Then you need to go to trial.
No, because this is the reason. If I go to trial, they want me to go to trial because they don't want to default on bonds. And if I go to trial and I get dismissed at trial, which I could, I know I would, but if I get dismissed at trial, they don't default on bonds. So this is obstruction because they are, and why do I have to get dragged into trial if jurisdiction doesn't exist and I can prove jurisdiction doesn't exist? You don't understand because this isn't what you do. I understand. Lawyers.
I've sat through a lot of hearings where people say there's no jurisdiction.
I'm not challenging it the way they
It's
do. I'm not on some sovereign citizen bullshit. I'm not. With respect, I'm deep in this law. I have taken it so
You
seriously.
haven't filed a proper motion.
Okay, I can't file a proper motion, so to speak.
No, you can't because you were given an attorney.
No, I wasn't.
That would be me.
Okay, and with respect, I'm going to overturn it because it's erroneous. And if it's erroneous, no one would have initiated from the beginning. It never existed. You were never appointed to me because it's erroneous.
That's an old one, Carey.
Have a second.
I feel like you're helping obstruct this.
I want to advise you.
What happened now? What'd you say?
That what you had pulled up right there was the old one.
Oh.
You may be included.
I want to advise you. To help you just in finding you're incompetent. I've seen judges put someone in custody for doctors to interview them to make sure they understand and what they're charged with and how to be defended or defend themselves. You're not defending yourself in a way
What I ask,
that's been helpful.
What I ask is that you awarded the good faith, right? If there's honor in this court, give this man the good faith effort to present his presentment to the court based on the merits of what he filed on the ex parte applications. Let him present so unimpeded. And it'll be.
I'll tell the judge that's what you want.
It'll be brief, yes.
It'll be brief?
It'll be relatively brief, yeah.
And that's based on the paper?
Based on the paperwork. Everything.
They're not even on legal.
This is for me to read. I don't give them this.
Oh, I thought you filed something.
I filed this. I don't need to file things off the paper.
Yeah, well.
I'm pro se. I don't need to follow the same guidelines. I just need to follow the same process.
You need to understand the procedure.
I understand the procedure. I have filed them. They don't need to be on paper. There's federal case on that.
No, that's fine.
Okay. So I filed them and I have served all parties this is done, and then I filed my certificate of service.
When did you file the issue of jurisdiction? Because the DA has a chance to.
So I filed that a long time ago.
Oh, you did.
And
has it already been litigated?
It's been litigated, but again, if it's improper and I can prove it, I've never had the chance to prove it. So this is the thing. First of all, two things. Jurisdiction, once challenged, must be proven by he who asserts. So the prosecution must prove. Prosecution's never proved jurisdiction. Let me tell you what they have done. What they have done. What they have done is they have alleged that criminal activity occurred in Riverside County. They said that he was pulled over in Riverside County and arrested. There was a search. That's it. That's all I said. They didn't even talk about the search warrant. They don't want to talk about the search warrant because it's not valid.
Why were you pulled over?
What
did they say?
Alleged swerving on the police report says he was swerving within the lane, which is not a violation of that code. The language of the code is clear. So long as the individual is within the entire lane, entirely within the lane, is correct. So long as the individual is entirely within the lane, it is not.
Did you pull over
I
right away? Because I don't have the benefit of having this.
No, I pulled over respectfully when it was time. Right? I attempted to pull it. It took me maybe 5, 6 seconds to
a safe place.
Not even 5 to 6 seconds to be like, it's because he was with me. Is he pulling me over?
It was like right by the exit.
Yeah, I was like, is he pulling me over? Or is he going after somebody else? Because I didn't do anything wrong, right? And then after I realized
I understand your level was low.
It was 0.9. It wasn't 0.9. It's like, I know how much I drink. And it's impossible to even be close to 0.9.
I think you would have had to have 3 drinks.
I would have had, no. So the blood draw occurred at 3:40, I believe 3:30 or something.
a.m.?
3:30 a.m.
In the middle of the night?
So,
and what time did they stop you?
They stopped me about 2:30.
Okay, it's a presumption that's rebuttable that if it's within 3 hours. But if you go to trial, the DA shows, well, at the time it was probably higher, and then the defense says, no, at the time, we have an it'll say, no, at the time it was probably 0.07, he was fine. That happens at trial.
I'm aware of this, but you don't understand. I know how much I drank, and it was far less than 3. I'm not going to say numbers, I'm not going to say numbers. But I know, because I was his DD. I was his DD. I was his DD.
Sometimes the DD is whoever had less drinks.
No, it wasn't just that I had less drinks.
So where were you drinking?
That doesn't matter. No,
we can get a person working here to test the
questions. That's not my job yet. That's implying.
Trying to help you.
Okay.
To prove.
We wrote a lawsuit because they want to give you an attorney, right? Which is
yeah.
Okay.
I'm a private attorney. People pay for me. I'm not a public defender. They have what's called a conflict panel. That's when the public defender declares a conflict. They don't want to deal with it.
Let me ask you a question.
And then they hire me or another attorney.
They hire you?
No, it's an independent contract I have.
Okay, let me ask you a question.
It's not through the PD or DA or anything. It's a private law firm.
Okay, let me ask you a question.
So you see also, just for everybody, just for clarification, how the private attorney is speaking about how there's a conflict of interest in relation to a public defender. I just thought y'all might be aware of
that.
Do you believe in due process?
I never should have talked to this lady anyway. But by the way, don't ever say half the shit that I said. I shouldn't have said any of this shit to this person. But I was just under extreme duress because I'm like, these fucker. I knew what they were doing. And I told her, you're aiding him in his destruction, which is fraud of inducement and fraud of infactum. You can look those definitions up. What happened to me right here is exactly what that is. They're trying to push a narrative that they're trying to help me by assigning me an attorney. But what they're trying to do is silence me and shut me the fuck up and try to, take me off the path of what I'm on and put me on the path of, go handle it at trial. Guys, up to this point, I never brought up any of the spoliation or discovery violations whatsoever. And so if you don't address those things before trial, they're moot. You can't bring it up in a 1983 action. You can't say malicious prosecution that the DA withheld certain stuff from me in a 1983 action because they're going to say, well, did you ask for it? No. Well, if you never asked for it, they didn't withhold it from me. There's a case, I think it's U.S. versus Williams, that states that the DA has got no responsibility to divulge all exculpatory evidence to you unless you ask for it. So just kind of be aware of this. This is what was going on. I knew what was going on. And at this point, I was like, no, I need to have in my mind. I'm like, I need to have an evidentiary hearing to address the spoliation, which is the documents that the judge was talking about in the beginning. He said he filed some documents yesterday, blah, blah, blah. Some of those would be procedurally needed to talk to in the future, blah, blah, blah. I had filed my demand for stay and alleged the spoliation of the evidence and produced a chart that had all the timestamps where I'm alleging. And I said, this needs to be addressed before we go to trial. And now here we are. Now you guys understand why they're trying to force this to trial so much, because if I don't bring that evidence spoliation up before trial, then I don't have a claim that they withheld exculpatory. You know what I'm saying? There's no Brady sanctions against them. So you guys can understand the concept of why this attorney is trying to. Well, that's what you prove at trial. Why don't you go to trial? They're really trying to push trial.
Do you believe in doing the right thing?
Yes.
Do you believe in individuals sticking up for their rights?
For the rights, yes.
Do you believe that?
No.
If I know beyond a reasonable doubt that I didn't do what they're claiming I did, beyond a reasonable doubt, 1,000%.
That you weren't DUI?
That I wasn't even nearly intoxicated.
Okay.
I couldn't have even been over 0.03 at the time of the trial.
That's a trial
No,
issue.
stop. You're getting too far. If you believed that if you knew you were innocent, why would you want to go to trial? Why would you not?
Well, why would I plead guilty? Your option is you plead guilty. You keep pleading not guilty until they get smart and says, okay, he wasn't. But they never do that in this county. Okay. So you have to go to trial and win.
So what you're not aware of is all the instruction that has occurred during trial. I have a document in federal court. And when I say document, I mean document. You don't know that because you've not been present. And I know that. I know every single tactic he's using. I know he's trying to claim me incompetent. I know he's trying to.
Is he the judge?
The judge. I know he's trying to claim that there's no merit. He's making sua sponte rulings without memorandum of law. That's what he's done. He's done it all. The whole trial. He's made sua sponte rulings.
But this is set for trial.
Okay,
it needs to go to trial.
It can't go to trial if there's no jurisdiction. Look at this. Look at this. So okay, how can you just move it along? I'm gonna finish it right here. I promise you, she's gonna be done. I promise you.
This is the.
Y'all hear how my boy talking to these attorneys, bro? My boy out there running and shit. Like, y'all can't talk to me like I don't know something.
Yeah, he's giving them motherfuckers an education.
I'm telling you. That thing, like, what?
Yeah, right.
They're like, yeah, we
Michael,
can't run over this guy. He's not present right now. But yeah, like, that shit's cool, bro. He's doing good. What's up?
Has he had a chance to depose everybody involved, including the lab tech?
I think he did have an evidentiary hearing, but he said he didn't run it the way he wanted it to get ran. So, or something. I'll have to ask him when he comes back. But yeah, one of the things for me on that evidentiary hearing was definitely when it went from consensual to non-consensual, because it was kind of just at first just checking up to see if everything was okay. And then he just demanded ID, and he even said homeboy didn't swerve outside the lane, but then in the report he said he did swerve outside the lane, so it's like, shouldn't have pulled him out the car, but he did. He told him get out immediately. I mean, I don't even think it was 45 seconds. But, hey, there you go. Ralph wanted to ask you something, bro.
Have you done any depositions on any of people involved, especially the lab tech?
No.
And didn't you have an evidentiary hearing?
So I had one evidentiary hearing. They never gave me notice it was an evidentiary hearing. What happened is I filed my motion to suppress and motion to dismiss. The clerk put a date on that filing and gave it to me. And then on that date is when they held the evidentiary hearing. So mind you, at this point, I don't know. Like at that point when I filed that, I didn't know the procedures of the court process. I've never been through it myself. When I took over by myself and fired the public defender, I'm thinking I don't know everything, but I know enough to know that they're fucking up. And so I didn't know the procedures on how everything works in evidentiary. I didn't know about dispositions. Or is it dispositions or depositions?
Depositions.
Yeah. So I didn't know about depositions. I didn't know about like those kind of procedural things, right?
Without a deposition, everything is hearsay.
Yeah, exactly. I know that now.
It has to be sworn to on the record through a deposition. Here's another thing
Again,
that you might want to.
That is cross-examination for everybody as well. Just so you know, it's a guideline that they have to provide to you the eligibility to cross-examine any person that's bringing in any out-of-court statements. Because again, out-of-court statements are hearsay, and if you want to exclude those out-of-court statements, you would file a notice and demand or motion in limine. But you could probably hit it for a notice and demand in limine as well, and structure it differently to stay in the constitutional framework and body of law instead of statutory. And but either way, it works. I've used it, and once you start hitting for them limines, bro, they better start bringing people in to testify. And there can't be no layers to testimony either. It's like, well, he said that she told me that this happened. No, what is your firsthand accountability, and what did you see? Because that's all that's coming in. Everything else is excluded. So, okay, go ahead, Ralph. Sorry.
When it comes to time for picking your jury, they're going to give you jury trial, not trial by jury, because you're not in an Article III court. But here's one question you can ask them: are they a U.S. citizen? And then find out where they live. And if they don't live in the District of Columbia, or they are not a government agent, you can impeach that person.
I like it. That's really good advice.
I'm not stressed. It's just I know what they're doing. I know what they're doing.
Okay, so they did under Schmerber. They used forced blood.
Schmerber. So this search warrant is invalid and legally moot on its face in all the court. It doesn't.
Did they get a body worn camera?
No.
Or you don't know how to do that? You need to ask for a body worn camera.
They don't have a body worn because they're CHP. They have
surveillance
only. And I requested those in Moral, and they didn't provide it.
You need that.
And they didn't provide it.
You need to ask for it again.
And
if they don't provide it again, the judge should do an U.S.C.
If they honor my right to be heard and be heard right now, and I am allowed to present my case, and if the judge says, I'm going to deny based on this, I'm going to make my ruling on order of the court, you can appeal it, right? Because this jurisdiction is an appealable matter. So, and I've already asked to appeal the judge's decision at the
Then we need to put over the file far.
Hold on. Please hold that. Please. Okay, you want me to hold these two?
Yeah, I know you.
I'm sorry. So when the judge, at the evidentiary, when the judge ruled probable cause, I gave him verbal notice that I intend to appeal. Please hold it, because I'm going to go over it. I'm going to go over it.
No, we don't need to. We don't need to. Your issue is jurisdiction.
Okay, so let me just read this real quick, and then you can see none of this is here. So under Gerstein versus Pooh, the search warrant must be within 48 hours of seizure. So it's in violation of county rules, because it's not within 48 hours of seizure. It cannot be absent a wet ink signature. It must be a wet ink signature or valid oath of affirmation rendering the warrant void ab initio under State versus Polly. Right? Under U.S. versus Hotel, a valid anticipatory warrant, it's a violation of that. I have these on my paperwork.
I see that, because that's not Schmerber.
No, you're
It says they can force what?
no, all that doesn't matter. So, gosh darn it, I have my paperwork for, because all of my stuff is on file, so I can say it, I can just read it right. Let me just grab this computer. Are there any documents that were obtained from anybody in here? That's a question.
From where?
From this area. Any of my documents obtained?
No. Does he help when we talk about these guys? Is that what you want?
Hold this, please. And no, it's not that. Maybe right here. Yeah, it's right here. Okay. So, over this, if what I tell you right now makes sense to you, hold up. If I tell you what I tell you right now makes sense to you, and all this is in my paperwork before the evidence hearing. Okay?
We should put this over so I can sit down and read and look up the cases, because this is new stuff.
So, listen. Under Gerstein versus, these are my notes, okay, just my notes, not files. Under Gerstein versus Pooh, a prosecutor's assessment of probable cause is not sufficient alone to justify restraint of liberty. A judicial determination is required. There must be a prompt, neutral, and detached judicial determination of probable cause following a warrantless arrest. That never occurred. The officer never took me before in a magistrate. He did the Schmerber thing, okay? Now we'll continue. Why that? Even if we get past that, there's multiple violations. Under Lopez versus United States 373, courts must not uphold convictions based on unconstitutional evidence or defective procedures. State versus Public, rubber stamped or electronically signed warrants are insufficient to meet Fourth Amendment requirements. It's rubber stamped. Let's check, please. You're going to see my argument. And if these documents are invalid, if these documents, yes, that's his signature. Yeah, this is electronically signed. That's rubber stamped. It's not a wet ink signature. So the warrant,
this is a copy of it.
No, it doesn't mix. This is what they provided me in evidence. This is what they provide.
I know the court probably has.
No, absolutely not. No, and if they do, they can. Guess what? Under Brady, they withheld exculpatory evidence.
No.
They withheld evidence. It may not have been exculpatory if they alleged wedding, but they withheld evidence. Why do I not have the authentic warrant? You can't try and help them. I know what I'm talking about. They're not done. This is the rest, the affidavit. So on the right here.
You see what you just tried to say, guys?
An anticipatory warrant must clearly and narrowly specify the triggering event that justifies the search.
Go ahead, because she did.
Did you see, guys? Did you see what she just tried to say? Maybe that's not the warrant, the actual warrant they used, is what she said. Maybe that's just like a copy of the warrant or some shit. You see? Are you kidding me? Are you fucking kidding me? And then pay attention, guys.
She's going based off of like her experience. Maybe she's seen it before, and that's what's crazy in and of itself. But maybe she's going off experience there on this is what has happened before.
I mean, maybe, but just keep in mind, by the way, at what point in this whole conversation with her do her and I talk about entering a plea and whether I should plead guilty or not guilty and what my rights are regarding that? We never converse that. She ends up entering a plea on my behalf without me, without me entering the plea and without her and I ever discussing it, which is fraud of inducement, in my opinion.
I mean, you could argue for that.
Yeah. In my opinion.
Okay, we'll keep going. Sorry.
Let's talk about the blood.
No, yes, no, this is a warrant, an anticipatory warrant.
It was a warrant for the blood
search. Yes, which is an anticipatory warrant. That is what anticipatory
warrant. Which they are allowed to do.
I'm not saying
if you're not cooperating.
I'm not saying they can't do what they did.
What are you saying?
Listen to me. An anticipatory warrant must clearly and narrowly specify the triggering events that justifies the search. And I have hold on.
They're saying they think you were driving on the other.
Either on the face of the warrant or on the face of the supporting affidavit. It's the full, right? Find that for me. Anywhere in there, find that for me.
Right here. To show a person has committed a violation of B.C. 23152.
No,
that's the
narrowly and specifically, it's equating to probable cause.
And then you refuse a law enforcement officer's request to submit to.
So that's not right. That's allegations. Those are just mere statements. It does not say under this condition I did an FST on Mr. Carey. When I did the FST on Mr. Carey, he failed a walking turn. He failed at this. He failed at that.
Did you refuse to do that?
No, I offered no. I didn't. And you could love this. I told the cop. I said I'm not answering questions.
You want to do an FST?
No, I'm not. Yes, I said I'm not answering questions. I won't do your practical because I knew he pulled me over on bullshit. And then he said, I didn't even determine if you're safe to drive. I said, I'm safe to drive, right? He said, I said, you know what, I'll do an FST for you. I go to do the FST, he gives me 2 commands at once, and this is on the record at the evidentiary, he admitted to it on the stand under oath. He said, look past my right shoulder and follow my finger. I said, which I'm going to do first? He said, that's it, turn around and arrest me. And on his arrest report, he said that I refused to take
These are triable issues to show that you weren't
I understand what you're saying. I understand.
You need to just let it go to trial.
No, I understand.
Just let the procedural violations go and go to trial. That's crazy, bro. That's crazy work.
Yeah, and
that's a straight up sellout.
That's a sellout, y'all. And
that's crazy.
Guess what?
Work.
She'll be a co-defendant.
That's crazy work, bro.
Crazy work, bro. And
right,
I just
Joe.
showed her the shit.
See you later, Joe.
I just showed her the shit, and I just told her what the law is, and she's going against it anyways. That establishes mens res, which is mental capacity. You understood what I was saying, or you had the opportunity to at least understand what I was saying, and you still went opposing it anyways. Yep.
Yep. He said, yep.
Oh, shit, bro. Understand what you're saying. I understand what you're saying. This is how my.
Wait, what?
I said he's doing a very good job.
Oh, yeah. He's staying on point. That's why I said I wanted to host him. So, like,
thank you.
You can see what it's like to just really get in here and get nitty gritty, because even these lawyers gonna be saying stuff, and it's like, bro, I'm knowledgeable. Like, you're not really just gonna get over on me like y'all been doing with everybody else. Y'all understand? I understand that I'm the highest of this shit. So we just gonna have to argue this shit out.
This is my rebuttal. How can this go to trial if the jurisdiction, we have to talk about jurisdiction. I'm not fucking sovereign citizen. I know how the process works. Jurisdiction is conferred to the court by the district attorney by initiation of a complaint and a summons, correct? Mm-hmm. Okay, so when that cop arrests me and then he does what he does, he gives me a summons, right? And that's a promise to appear, yes?
Sometimes they don't.
That's what they did. So I come, and when I come, the DA will give, when you come for your arraignment, the DA gives you a complaint, yes or not?
Yes. You are the attorney.
Yes. That is how jurisdiction is then conferred by process. There's a summons.
So you're saying you never got a complaint?
No, that's not what I'm saying.
What are you saying?
If the complaint is established on invalid documents that have no legal merit in the first place, then the complaint itself is invalid. And if the complaint
did a motion, I heard you did a 1538.5 motion.
What does that mean?
Search procedure, illegal search procedure, saying that everything you're saying now. That's all the DA told me. I've been here 3 minutes before you.
I did a motion to suppress evidence and a motion to dismiss.
Right.
The judge erroneously.
Well, then you need to take. You can't relitigate it now.
Do I have a right to appeal that? A 1538.5?
You can, yeah.
So you're saying I do have that right to appeal that?
Yeah.
Okay. So when he made his ruling, I told the judge, I'm going to appeal that decision.
You have to do it quickly.
I told him immediately.
No, you have to do it. File the proper papers.
Yes, I understand. I'm aware there's a timeline, right? Well, actually, there's never a timeline for a erroneous. If it's erroneous in all legal accounts, there's a void judgment is void ab initio. So I'm gonna get to it. I told him, if you have this ruling, understand, I intend to appeal, right?
And he said, fine.
He said, oh, I support that. Guess what happens? And I have video evidence of this, all right? Guess what happens when it goes to clerk and I ask for the judge's ruling? By the way, on the record, on the stand, he said, I'm gonna find probable cause because you were argumentative. That's ambiguous. That's not supported. No, it's ambiguous.
That's a reason to not let you represent yourself, because you're taking up 45 minutes of time on things.
Because I'm trying to catch you up on things I don't know.
And I don't do the trial. I just am here to say, conflict panel's appointed, I will get a trial attorney to help you.
1 minute?
Give me 1 minute.
No,
I'll give you 1 minute more, because I need to get in there.
I need 5 minutes when I'm in there to present my thing and I'm done. If this is wrong, the complaint was void ab initio and jurisdiction cannot be conferred to the court if jurisdiction was not established on proper documents.
But you already had a 1538.5 motion to that effect.
But this is the issue. The burden of proof is on the prosecutor.
No, it's not.
To prove jurisdiction, yes it is. Yes, it is to prove jurisdiction. That's the only challenge with the burden.
Yeah, and it's not beyond a reasonable doubt.
Okay, but it's on the prosecutor. And the prosecutor,
they can use what the cop
says.
They
need to use, I have the arrest, and by the way, I have the arrest warrant, I have the arrest report, and I have the search warrant.
Your attorney who does the trial will get that.
Why will you not listen to what I'm saying? If the complaint is established on documents that are legally,
they're not accepting that.
You can't not accept it. You can't not accept it. That's a violation of the process, right?
Okay.
Does this make any sense to you? If the complaint's established on legally, this is just paper. It has no legal force unless it follows the law.
Okay, I'm not saying what you want to hear. I'm telling you what an experienced attorney will tell you.
Jurisdiction can only be conferred by statute or law. And law says this does not confer jurisdiction.
But you already litigated that, I
understand. No, I didn't. I was heard on this matter. I didn't get to put this into evidence.
Jurisdiction?
Yes, I didn't get to put this into evidence. I didn't get to put this into my case because I was expecting the prosecution to prove jurisdiction. The second they brought this into trial, I was like, but they didn't bring this into trial. That's what I'm telling you. And with jurisdiction, it must be proven.
Okay, if you want a hearing on that, they're not going to let you do it today. You have to give the DA notice.
I already did. That happened on Monday. I gave them notice before Monday.
Not a 5-day notice.
Oh, hey, guess what?
We'll see if the I'll see if the DA's already.
So with respect,
normally they get sending notice, and then they can write a response.
Fair.
And then you can write a response to
I'm
that.
going to propose to you, because I promise to God, if you claim, if you act like my representative, I'm amending that complaint for 1983, and you will be included. And I say that most respectfully.
The judge just appointed me to be your
attorney. I
attorney.
told you how he can't. I have a right to rebut that. I just read the case law to you, miss. I just have a right to rebut. Let me just rebut, get my rebuttal, and if you allow that, guess what? I feel like you honor my right to be heard. And then, Judge, you can make your ruling. I'll ask for you to put it on written order, because once I told Gallon that I intend to appeal his order, and he said...
You gotta respect it like, hey man, I'm not giving up on what I know. So I'm gonna just keep riding with what I know till I get what I want. Like, hey man, sometimes you just gotta be persistent like this, bro. You just gotta keep going.
Gallon was the judge for the evidentiary. When I told him I intended to appeal his order immediately, he said, I'm gonna find probable cause because you were argumentative, right? So I told him I was gonna appeal. Guess what happens when I go to the clerk after my surgery asking for the order from him? Because I can't get it from the court reporter. Because the only thing that's gonna be on the court reporter's record, from the court reporter, is...
I can get it online. But you don't want me to help you. I can get on there now and print it out.
Let me ask this though. If we get that court reporter document that says, I'm going to find probable cause because you were argumentative, how can I take that to appeals court and say, I don't quite understand what you're saying. I need clarity first.
Is there a court reporter in Gallon's?
Yes, there's a court reporter, but that doesn't matter. What he said is ambiguous. And guess what? A judicial officer's ruling cannot be ambiguous. It must be left out.
Okay, I understand. I will tell them.
And when I go to get the order from him and I say, hey, I would like the order so I can deal with this, what they say. There doesn't exist one. And then what they said, I got it recorded. It's confidential. Guess what that violates? That violates 15.
Yeah, go ahead.
Is there any way to invoke your ADA rights or get an ADA advocate? And with that, all of those transcripts come to you free of charge.
I'm not sure because I don't know anything about it. If you want to enlighten me, I'm open to hearing.
Yeah, there's a guy out of Texas that he's an ADA advocate, and here's the thing. Is you don't have to disclose to the court because it's under HIPAA what your disabilities are, but they have to make accommodations. And this is federal law.
Okay.
So that's something to look into.
Yeah, they do have to make accommodations.
8.5I, which says that it must be preserved on the record in a meaningful way so as to honor the right for the appellate.
What's the date of that order?
If there is no order.
No, of the hearing.
The hearing was 425. And you know what? With respect, I'm done talking to you because I don't trust you.
Okay. You're done talking to me, so. I guess we should hold it. Over here. Are you ready for me to be here? Yeah. Just hold it. Okay. That's not up to me. I will ask the judge to leave. It's up to the judge. I don't control recording.
I have invoked my right to rebut.
Are you ready to go? Yes, go ahead.
I have been informed of my...
I have, and I will advise the court. He will ask me what's going on. He will tell me that.
Remain seated and come to order. This court is now in session.
Thank you, Your Honor. Yes, I've spent the last 40 minutes or so talking to Mr. Carey, and he has presented me with some of the paperwork that he has. He basically claims that he is rebutting anyone being able to be his attorney.
Okay, well, I've already made a decision on that.
And I told him that. And he can appeal that if he wants to. At this point in time, he wants to rebut that, but
with restatement of judgment.
It's up to the court.
The train left the station. So what date would you like the trial?
Absolutely not. For the record, that is obstruction of justice. You have been served. Here you go. Here you go. No, yeah, you touched it, miss. You've been served with respect. With respect. Yep.
All documents, they're relevant.
Oh, they're absolutely relevant.
I have further information when the court goes.
I do not consent to you seeing
I'm going to return these back to Ms. Johnson because these are things that don't need to be served directly to the court.
Oh, absolutely. I don't care if you accept it. I'm going to take this is already going to federal court. I have a writ of prohibition that is right there. I will be amending that writ of prohibition under 1983. If you do not allow me to rebut under restatement of judgment, I have a right to rebut your ruling if it is incorrect. If your ruling is erroneous, it's void. If I can beat your ruling with law, rulings must be established by statute or law. May I be heard?
No.
That's obstruction.
I now cited you for contempt California Code of Civil Procedure 1209A1, disorderly conduct or a judge intending to interrupt the proceedings. Code of Civil Procedure Section 1209A5 for repeatedly disobeying court orders to stand down and proceedings. And Code of Civil Procedure Section 1209A9 for disobeying lawful court orders and interfering with court proceedings and processes. It is based upon everything that I've already said with a number of interruptions, including what you just did a few moments ago. I have given you repeated warnings with regards to having to stand down so that we can go on with our proceedings with what's before the court. You have repeatedly obstructed this court, repeatedly interrupted it, and have caused this court to be paralyzed and unable to proceed in not just an orderly fashion, but in any fashion. So at this point in time, I'm going to take a 5-minute recess, let you consult your counsel as to whether you have already proceeded after that contempt trial, which is direct contempt because it happened in my presence right now and over the last couple of times you've been here. Ms. Johnson, I'll stand down so you can consult your client as to how he wants to proceed, but I am intending to go forward with a trial today.
I do not understand.
It will, as you know, it's punishable by up to 5 days in county jail and up to $1,000 fine. I'd be happy to consider any change in attitude by Mr. Carey as to whether I drop the contempt citations. 5 minutes.
All right, thank you.
Judge, I don't understand. Can I ask a question for clarity?
This is part of what he's talking about.
I don't understand what he's saying. I need to ask for
Let
clarity.
me clarify it
If
for
he's the
you.
judge, is he a disinterested third party prior fact?
Right, and I'm your attorney.
No, you're not.
Yes, I am. He appointed me.
He cannot force attorney on
Let's
a violation of
not
the
do
6th
this in
Amendment.
public.
What, for the record, the 6th
There's
Amendment.
no record on. The record's only there when the judge says there's a record. Okay, you're talking yourself into jail.
I'm not trying.
Yes, you are.
Listen, with respect, if I gotta go to jail, he's going to jail after. Know about?
Can we talk like that?
After I get these people's information. Miranda?
That's great.
What is your badge number?
Nora 965.
Oh, say again?
Nora 965.
What's Nora?
N.
N? 9065? 7538. You touch those documents. You should do. Arius, what is your name?
Nora 8569.
Hernandez. What's your badge number, sir?
4414.
Right.
Okay. I served you a notice of full commercial liability for obstructing my right to due process, and you should read it. I will be including every single one of you in a federal lawsuit if I get arrested for not preventing my rights being violated by a judicial officer under color of law. It's in the notice. Every single one here. It happened right in front of you. I have a right to defend myself under the 6th Amendment, which supersedes his orders. A judge cannot force an attorney upon a person. It is scrupulous. It is a scrupulous standard. Under the scrupulous standard, an individual has a right to defend himself, and as a pro se litigant, my pleadings must be liberally construed. He cannot liberally construe my pleadings if he doesn't allow me to speak on the record and state my rebuttal. His decisions are not absolute. If he can misspeak, he can misspoke, he may say some law that, you know what, that law is incorrect. I restrain, I resubmit that order.
You can appeal.
I'm not gonna, if it's erroneous.
That's why you would appeal.
Which it is erroneous. This is obstruction under 1983. You've been served, and it happened in your presence, and it happened in your presence, and it happened in your presence, and it's okay. The judge is going to do what he's got to do. And
But I'd like to talk to you, tell you how to get out of this.
yes, I'm okay to go to jail because what that does to him after, and I don't understand the evidence that I have of all the obstruction that has occurred in these proceedings and in this trial. And I know exactly what he's doing. He's trying to hold me in contempt. He's trying to feign that I don't know what I'm talking about. I don't know the law. He won't let me speak my law. And if he gave me the opportunity, if he comes back right now, gives me the opportunity to present my defense.
Come on, let me talk to you.
I'm telling everyone here, if he comes back and gives me the opportunity
You're
to
just
present,
hurting yourself.
if he gives me the opportunity to present, if I'm hurting myself by saying I just want to present what I've given to the court,
But he
let me be heard.
gave me 5 minutes to tell you about OSC, and I want to try to tell you how to get out of it.
I said, listen, I just want to be an opportunity to be heard, and everybody has witnessed it. That's all I ask
And he
for.
says you've been heard before,
I
and he's
have been
ruled
heard
against
on any
you.
of these, and I just gave him documents that have never been addressed
Okay.
in support of the ex parte motions. And there's an exhibit appendix that states these documents are in support of these ex parte motions. I did right process.
So I'll ask him if he will at least allow you to present about
I just
the
want to be heard.
jurisdiction.
I
Okay,
just want to
can
be
we
heard.
talk? I'm trying to help you. First of all, will you listen to me, please? Before he'll let you present, I want you to do this. I want you to apologize for interrupting. This is so strongly ingrained in you that you have not been able to help your day in court. You want to settle this jurisdiction on other issues first, right? But you need to apologize.
told him, he'll never give me an opportunity to speak. You don't understand.
He'll say, Ms. Johnson, what if you decided he would like to apologize for his speaking over you, and he just feels that he is.
I do not consent.
You don't want me to say that?
What I consent to is he apologizes.
He's not you
that he apologizes if his desire to be heard in a meaningful way interrupted these proceedings. He respectfully apologizes and declares he simply wants to be heard in a meaningful capacity on his argument that's never been presented before the court.
So tell me your wording again. I can't say you apologize if he's going to let you speak. You need to apologize first. That you apologize and would like the chance to do that. And then
So I'm not going to apologize per se. I will word it how I need to word it. Okay? Mr. Carey did not intend to interrupt these proceedings. He respectfully asserts he wants to be heard in a meaningful capacity, and that's about that has not been allowed to.
Mr. Carey did not intend to interrupt these proceedings. He merely respectfully wishes the opportunity to be heard. The opportunity today.
To be heard. Today. Yes, right now.
Today. To be heard.
In a meaningful.
On what issue?
On jurisdiction. Which can be challenged at any time.
On the issue.
He's like, right now. I want to hear it. See, the thing is, too, though, is that if you had, that's why she kept saying right now, but you could have just been like, yeah, call for a jurisdictional hearing, because, people call for those, and they go in depth on those arguments with case law and just deeper arguments, too. So you can call for jurisdictional hearing, you know what I'm saying?
Yeah.
And it gives them time to, argue, and then the judge to be prepped and set, and the time to be allocated for that. Sometimes but it's like weird too, because this whole thing going to trial now, it's a contempt, it's like direct contempt, and do you want to talk to? It's all over the place, bro. This shit is like in this hearing alone, you've got so many different factors moving. It's like, man, they just took you from pro se. Now you got somebody randomly on you. It's so weird, bro. Like
I was lost, bro. I was like, I don't know what I knew what they was doing. I just didn't know how to audible. I was like, fuck, how do I deal with this? All I know is I got to tell her I don't consent to her representation, and I got to tell her that she's aiding the court in obstruction if she tries to do that. And I just know I can't apologize to the fucking court because I didn't do anything wrong. And if I apologize, that's basically admitting guilt. That's all I knew.
Yeah, I think a big deal here too is that man, bro. I mean, the disqualification you should have hit from right off the bat once that nigga yelled, but.
Yeah.
I mean, you can see how it just went from flying straight to just boom. And I don't think a lot of people could have handled all these movements going on at once like you did.
Thank you, bro.
Yeah, so that's why I say I commend you, bro. You for all this to be happening at once to you is pretty
They're
major.
throwing a 5D chessboard at you on a checker table.
Yeah. If you didn't know what you were doing, it didn't look like you didn't.
Yeah. I mean, I really didn't.
You look good in there.
Thank you, bro. I just knew what they was doing was wrong, and I didn't really know how to respond, but I just tried to be careful with what I said and how I said it because I knew I was recording everything, and I'm just like, fuck, I just know I need to tell this lady that I don't consent to her representation. I need to show her what the law says so that she can't say, oh, well, I didn't know, right? Because I had to establish mens res, right? You had the mental capacity to understand what I was saying, and I showed you verifiable proof in person. By the way, I had my buddy right next to me this whole time as a witness. And I just knew certain little things, and then how it was gonna play out, I did not know. I was like, fuck, at this point in time, I wasn't sure if I was gonna be arrested, but I was ready for it. You'll see when that happens, when they do it.
Based on new evidence.
What's the new evidence?
What I gave them. The affidavit. The search warrant. That's never been before the court. It's in the ex partes. The exhibit is in support of the ex partes, and the exhibit appendix lists the documents that I gave them.
Which would have established jurisdiction.
Yes, which is required. It must meet legal standards to convey jurisdiction to the court.
And the judge will ask you, well, have I had a chance to review all this? I go, no, I don't have any.
That's what I can do right now. I can do it right then. He has it right from it. It's not.
They don't do that.
Okay, if you want to bring this back at a later date, I'll respect that.
It'll be a couple weeks or so, but do you care anytime?
On a Tuesday.
Jurisdiction can be challenged at any time,
They have to agree
even
that.
after the fact.
Say that again.
Jurisdiction can be challenged at any time, even
Yep.
after sentencing.
Yeah.
And I told her that. I told her that earlier in this video.
Your attorney. No, you would do it yourself.
You can't challenge jurisdiction before the trial. You have to do that trial. I'm trying to challenge it before trial.
I'm ready. We're ready.
Real quick pause. All right, I'm gonna ask you guys, when did her and I talk about entering a plea?
Not at all.
Did anybody
Never.
catch that?
I didn't hear anything.
You hear it.
Did anybody hear us talk about contempt and how it works and what's gonna happen when we come into this hearing?
No.
Okay. So what y'all did hear is me tell her instruct her on what to do, right?
Yes.
Okay, we're gonna see if she does that.
Remain seated and come to order. This court is now in session.
Record and,
Yes, Your Honor.
Mr. Carey, I assume you'd like to enter not guilty plea, or is he at this point willing to say or do anything to ask the court to withdraw the contempt citation?
He is asking the court to withdraw the contempt citation.
On what basis should I do that?
He's saying he did not intend to interfere with these proceedings anytime. He respectfully wishes the opportunity today to be heard in a meaningful, competent way on the issue of jurisdiction, which he says can be challenged at any time. He has new evidence that he presented in writing to you today that shows that the search warrant is not valid, and that's what he'd like to be heard on. And otherwise, there's no jurisdiction.
Let me add a couple things, okay?
Yes, sir.
There's already a 1538.5 motion that heard, not denied. That train is to the left. We're not revisiting that. It's a little offset. Was there a search warrant in this case?
Yes.
Okay. Yeah. There's no pending motion before the court. I'm not going to hear that. This is what goes to the heart of what my frustration is. He brings up things that have already been handled. I've already ruled, or other judges have ruled, or things that aren't properly noticed or filed. So I'm not going to allow them not to be heard.
Man, next time you just put the phone on the table, bro. Flat down. Just put the phone on the table, flat down.
Okay.
Now, juris counsel. As to the contempt, I'm really reluctant to accept his request to withdraw the contempt citation. I'm not getting any vibes from him currently that he's going to comply with any court orders to allow an orderly process. His intent was he has disrupted this court. Okay? So.
I want you to tell me that you will respectfully.
If you want to follow along with the rules and not interrupt, and he's not going to talk until it's time for him to testify if we get there. At a trial, and his lawyer's going to be the only one who files motions. He's going to respect that and not do what he's been doing, even as I'm looking at it now, attempting to derail what I'm doing. I will consider dropping the contempt charge. I'm going to ask him directly. Now, I'm going to want a yes or no answer from you, Mr. Chair. Are you willing to follow the directions of the court as I just laid them out? Yes or no?
I don't understand that question.
Right.
I don't understand.
He just threatened you if you don't take the lawyer, he's going to put you in contempt.
Sorry, say that again.
No, he asked him, do you know the rules of the court? Do you know essentially the rules of the court, the rules of the procedure, criminal procedure? He essentially asking, do you know rules of criminal procedure? That's what he asking.
I took that as if he doesn't freaking take a lawyer to represent him, he's going to hold him in contempt.
Replay it again for us, please, Cam.
Yeah, 56-17. Oh shit. 56-17.
And his lawyer's going to be the only one who files motions. He's going to respect that and not do what he's been doing, even as I'm looking at it now, attempting to derail what I'm doing. I will consider dropping the contempt charge. I'm going to ask him directly. Now, I'm going to want a yes or no answer from you, Mr. Chair. Are you willing to follow the directions of the court as I just laid them out? Yes or no?
I don't understand that question.
Right.
I don't understand. Can you just read?
No, we're going forward then.
I don't understand that question.
We're going forward.
Because I don't understand the question.
Are you going to stop interrupting him, basically?
Can you explain it to me?
Interrupting, you know what interrupting means.
So at this point in time, I've already made the record as to what the evidence has been.
See, it is me personally though. I would have had candor, bro, and I'd have just been like, I know the rules. I appreciate you considering to drop the contempt charge, but to be honest with you, I'm gonna, there might really there's a bigger issue here, which is the fact that it seems as though there's an emotional tie, and that's why you clearly had to remove yourself from the bench earlier in relation to yelling at me after interrupting me in the first place, even though you stated I had the time allocated to make my statements. So while I was not finished in those statements, Your Honor, so it's kind of like move forward on that disqualification on their ass because if at that moment, that's where I say I would have hit pretty hard is the disqualification and the recusal of said judge at that moment because once you see that the emotional tie is in place, you can see that there's a bias and there's going to be a prejudice, and that prejudice just leads back to the initial point of that emotional breakdown, which is what homeboy had on you. He literally had a whole emotional breakdown of. You interrupted me. And that to me is kind of crazy because I'm just not understanding why you would yell at somebody like that in the first place. So,
well, did you guys catch where he said that only an attorney can file a motion? He's forbidding Michael from filing any motions?
Yeah. Yeah.
So in essence, he's forcing that lawyer on him.
Yes.
Otherwise, he's going to hold him in contempt.
That's why I'm telling you it's fraud of inducement. Look up fraud of inducement and fraud of infactum, and there's case laws on it, and it states what it is and why it is. This is what they were doing to me. I didn't know this at the time. At the time, I'm like, what the fuck is going on? How does this judge think he's got the authority to revoke my pro per status summarily, without a hearing on it? And in the same sense, hold me in contempt, force an attorney on me, hold me in contempt, and allow that attorney to enter a plea on my behalf without discussing it with me, all directly, immediately, without bringing it. You know what I'm saying? All at one point in one hearing, at one time. I'm like, I ain't had a chance to go like research what's going on. This is a direct contempt, so I don't have a full due process right to the whole issue where I can subpoena transcripts and subpoena witnesses and subpoena this and that and have an actual evidentiary hearing for the contempt order, right? They're doing direct contempt, so it's right then and there. And I was just like, what? Like, I didn't know how to respond, man. I ain't gonna lie. I didn't know.
I mean, they did the same thing to Lana. They just run them right through. They like doing that and then bringing the officer up so they can get the evidence on record before you can object, before you even know. Yeah, they're in great claim jurisdiction.
Jesus.
Will have a right to testify as to the contempt order. On July 14th, Mr. Carey, in an untimely manner, filed a series of documents which were not motions but were rather demands, couched in motion language, most of it was incomprehensible. There's nothing about that that's contemptuous. The court addressed it or attempted to address it on Monday, but during the course of Mr. Carey was given an opportunity to speak uninterrupted for well over 10 minutes, and the report transcript will back this up. Much, if not all, of what he said was off point and had nothing to do with any of the issues before this court. The court on Monday, and even today, is only here as the master calendar for criminal cases, ascertaining readiness for trial, and then assigning cases out for trial if ready. The only potential motion that I would do would be if there was a motion to continue. Mr. Carey was asked if he wanted to continue the case and did not want to at that time. But he talked uninterrupted for over 10 minutes. At that point, the court did interrupt him immediately because he was off point, off target, off subject, and it was becoming disruptive to the court proceedings, and we needed to move on. When I attempted to redirect Mr. Carey and get to the issue at hand, which was readiness for trial, he interrupted me, and then repeatedly interrupted me. As I acknowledged at the time, I raised my voice to tell him to stop. It's my turn to speak. He interrupted me again, and interrupted me again. I can't even tell you how many times he interrupted me. He would not even allow me to get any words out. The court was forced to take 2 recesses in order to get this court back in order and also get back to my other docket. That is the first basis of contempt. Now, he was given ample warnings today. Admittedly, I don't think I gave him specific warnings as to contempt on Monday, but today we started out the proceedings in a similar manner. He had filed yesterday with the court a series of other documents, which again I will simply present. I had read all of them and was prepared to address all of them when Mr. Carey interrupted again and again and again. And argued with me about whether I read them, They wanted me to read them on the record. I suppose he wanted me to recite everything he wrote on the record. I tried to redirect him. He interrupted. I granted him a request to postpone further proceedings until 2 p.m. because he acknowledged or stated that family emergency of some kind. I granted him that request. He did return, but before I did that, I had made findings that he had violated rules to the point where I could not allow him to proceed as his own counsel because he was disruptive, unwilling to follow court process, unwilling to follow court directive, and would, as I said, paralyze proceedings where we would never be able to move forward. Both sides have a right to move forward in a timely manner. This court has an absolute right for the efficient and timely administration of justice without chaos. The court had considered contempt earlier today. I decided against it, taking the less extreme measure by revoking his pro per status and appointing counsel in order to bring some semblance of normalcy to these proceedings. I'm mindful and was always mindful of maintaining Mr. Carey's right to have a fair proceeding and to give him an opportunity to have his case tried in a fair and impartial manner. But again, at every turn, he has got in the way of the court's attempt to try to get that done. Ms. Johnson came in this afternoon and with much appreciation to this court to attempt to represent Mr. Carey. And I appreciate the efforts you've made. It's been probably over an hour now that you've been working with him. As the court and everybody here can see, with the record request in the last 15 minutes or so, trying to move forward, interrupted me again and again. I gave him a chance to sincerely promise that he would behave in an appropriate manner, and in attempting to get a yes or no out of him, he again redirected the papers that my deputies handed to them. Again, it was gobbledygook that had no obvious meaning. I couldn't understand what it was he wrote. So here we are. Those are the facts surrounding these citations. And again, the conduct in general, as all three counts of contempt have to do with disorderly conduct toward the court, which tends to interrupt the proceedings, disobeying my orders repeatedly to stand down and allow me to make rulings, which is my job, from the bench uninterrupted, and his unlawful interference with the court proceedings by that behavior. I've entered a not guilty plea on his behalf. Ms. Johnson, the floor is yours for anything you or Mr. Carey wants to present in defense. And just as I look this up, I'm not going to take any comments about the substance of the underlying charges, the search warrant, the search, any of that stuff. We're only talking about his behavior in court.
Understand. Do you understand? What do you think of that?
I respectfully will not interrupt him, and I respectfully ask to be a simple rebuttal under his rulings. Simple. We're not about that. We won't address anything else. We won't address anything else that I presented. I just want to rebut his rulings on my own accord, not somebody, and then we can address any other matters. We can set that for later date so that all parties can review.
Your Honor, he has assured me that he will cooperate with the court. The last, at least 5 minutes or so, he has patiently stood here and listened to the court.
We'll pass the apology. I'm not wrong. If you'd like to testify, I'm happy to listen. Then they bear on the punishment if I find anything better.
Okay, and he wanted me to say he just wants his chance to rebut your ruling on not allowing you to be your own attorney.
That's been made abundantly clear, and I'll say for the 6th time, that ruling is final. So absolutely condemned. Mr. Carey would like to do that.
If you get up and testify, can we ask you?
If you'd like to tell me anything you want to tell me about the contempt, you push under oath and testify from there to join.
Yeah.
I'm absolutely welcome to do that.
Don't regarding contempt.
I'm happy to testify for contempt on my own recognizance, not under any representation.
You sound to say that the testimony should have been a matter not getting over this court. Should be the truth, the whole truth, and nothing but the truth, with that?
On my own representation, yes, I do.
All right. Good. What would you like to tell me about the facts about this item? Go ahead.
So, in regards to the contempt, I assure the court, I respectfully did not intend to interrupt, and I understand that it goes back ways. I do believe that in the past 2 proceedings, today and on Monday, it was kind of an interruption of both processes, right? The judge, the disinterested third-party trier of fact, and the accused kind of interrupted each other. I think that's a fair statement. So, with respect, I solely wish to be heard in what I feel is a meaningful way, and I felt like I have not been provided that opportunity, which I can't necessarily just shut my mouth when the disinterested third-party trier of fact is dictating what I say and how I build my defense. It's not my intent to disrupt these proceedings, but as a pro se litigant, my pleadings and statements must be construed liberally. And if it takes me a long time to get to my point, then I apologize, which is why I stated that on Monday. I state I apologize. This may take some time, but I just wish to be heard in a full capacity so that what I felt was my defense for that hearing, for jurisdiction, could be honored in a meaningful way. And when I felt like that didn't happen, which is evident by what occurred, I felt that you issued a rush to judgment, right? And I felt that you did not honor my right to be heard in a meaningful way. I preserved my right to rebut under rebuttal of judgment. I do just preserve my right to rebut your decisions, your rulings, under the authority of the Statement of Judgments, Section 24 and 27. That's all I reserve. If I can be heard on why I rebut your rulings, that would make me feel like my due process was honored. And I can go through a hearing with you, even if it's another day, on this matter. We can stipulate to perhaps an open term so that all parties can review what I have submitted to the court, and in honor we can proceed.
Well, you did ask, so that's good. I'm glad you did ask. That came through.
Because I truly do not want to interrupt the disinterested third-party trier of fact. But when it feels like, for instance, when you proposed what District Attorney Massey's take on jurisdiction was, you did that without her invoke or inciting that from you because she was quiet, she didn't state anything. That made me feel like you prejudiced. She didn't start that. You incurred what you felt was your opinion on her take, which seems prejudicial, extrajudicial, and ultra-virus. It just seems and feels that way. And even the appearance of impartiality is to be under strict scrutiny under the judicial.
Oh yeah, good job. You're hitting a little bit on recusal and disqualification, but you ain't push it all the way. But you did do you're hitting right there, even just a little bit. Just the appearance, and you screaming's definitely an appearance, bro. Like there's no doubt about that shit. Like you definitely appeared prejudiced. You're biased. You're out of there. You're tainted.
Gotta go.
You are tainted. Yeah, gotta go.
Canons, 1, 2, and 3. So with me knowing these judicial canons, and in my affidavit, I have that, I can only understand what I read. So when I read the judicial canons and I feel like your conduct is violating these judicial canons, I feel like I have to protect myself by objecting and trying to correct the record. That was my sole intent, Judge. I never intend to disrespect the court or disrespect anybody in the court. I believe on Monday you said that up until this point, I have represented myself as appropriate as could be in that manner, in the extent that I have followed the process. I have filed some motions, I've served all parties involved, I was heard on these motions, and we went forward. And the only reason why I feel like I haven't had my rights honored is because at the evidentiary, when Judge Gallen, he made his ruling, I told him I intend to appeal his ruling immediately. He said, I encourage you, or I accept that, so to speak, right? When I had surgery the following Monday, the evidentiary was on Friday, I had surgery on my knee because I had torn it. That was submitted to the court for my motion to continue. When I came back from surgery and went to the clerk and asked for a judicial ruling, it did not exist. And I got told by the clerk that it's confidential.
Okay, I am interrupting, and I don't mean disrespect. We're totally off topic. Please, anything else you want to say in your defense as to your behavior in this courtroom?
So as to my behavior in this courtroom, any behavior that has seemed inappropriate was not intended to be inappropriate. It was solely intended to uphold my rights, which as a combat veteran, I am very, very, very strongly adamant that, Americans have a true right under due process to have a fair trial. And when I couldn't get access to that, and then I couldn't feel like I was heard in a full, meaningful way on Monday, and then when I felt like that process was abandoned by the court without making ruling when you left the stage, when you left the bench without ruling and mid-conversation, you abandoned your duties, I felt like the fiduciary obligation to which you have was breached on my behalf, and that right there violated my rights to due process. Now, we did continue, and you gave an offer, and I said, in part, because I just wanted to continue my hearing, get the record, the evidentiary straight. So all of my actions today were to go over these documents in a meaningful way, and I assure the court, I probably didn't need but maybe 10 to 15 minutes to be heard unimpeded at that time. So I know this is... Okay, let me try to put it.
I want to give you the time you need, but you're repeating yourself over and over again. At some point, pass it. So what else do you want to tell me about your behavior that hasn't already been addressed?
So, as I said, I'm very adamant about my rights. I do believe in them, especially when I know I'm innocent. I resume my innocence always. And as an individual, when you feel like you've been wronged by the system, it's really hard to kind of keep your emotions when you feel like you can't be heard. Okay, and so the reason I acted as I did earlier is because a attorney appointment is an officer of the court. So if you force a plaintiff onto me, everything that I've been trying to convey to the court in terms of my defense that I haven't had a full opportunity to be heard on, it would be moot. Because jurisdictional challenges await immediately because an attorney is an officer of the court. And I cannot present my defense, which it may be different, right? It may be different from the normal because I'm not an attorney. But my jurisdictional challenge, if I can present that in a meaningful way, and then I get forced an attorney which waives what I'm trying to do, that seems extrajudicial and prejudicial. And so I just wanted an opportunity to convey that, and under certain authorities, right? Not my authority. I will, if I have the opportunity.
Hey, you're off topic. Okay. You've repeated it many times. Okay. The points are crystal clear. Anything else you want to ask? Last minute. That hasn't been said already. And again, respectfully, I'm going to cut you off if you're saying the same thing.
May I have 10 seconds to review something a little bit maybe more? I respectfully presume I did not intend it. So, to pretty much conclude why I would like an opportunity, and you can decide on this once I state this, to rebut your rulings on past jurisdictional challenges is because, under the authority of the United States First Lodgers, jurisdiction, once challenged, cannot be assumed or declared by mere declarations. It must be proved to exist as a matter of record.
I'm going to cut you off because that's all.
Is that not
you're arguing the motion that I've already ruled.
Telling me I can't challenge jurisdiction?
To conclude Mr. Carey's testimony. Mr. Johnson, do you want to add or
I think what he was hopefully was finally going to end with is an apology to the court. So I would ask if he wishes to do that.
Anything you want to add, Mr. Johnson?
Just that he is professing to be amenable to taking my advice. However, a trial attorney will be appointed for him, and I have told him that a trial is where he has the best chance.
That's all on the contempt.
Oh, on the contempt? No, nothing.
If that's all right, as I earlier recited them, I'm not going to recite them for the record, but they are already well established based upon my earlier presentation. Mr. Carey's testimony did nothing but actually affirm the finding I'm about to make, which is the finding of contempt. His defense is that was to attack the court, disparage the integrity and dignity of this court. I call it accusing of unethical conduct, accusing the court of process rights. To the contrary, the court has bent over backwards to protect the process rights. Even this morning, when I tried to, I told him I wanted to go through point by point everything that filed included today, which I think was untimely. He deserved to put on it. He cut me off.
Oh my God, bro. God, bro. Just killed my ears, bro.
I don't respect rights, and that I don't take them as seriously as he does.
Oh my God.
Right, very seriously as I do everybody's. The court will find that the defendant is in contempt of court under Code of Civil Procedure 12091. Disorderly conduct towards the court, intends to interrupt proceedings, disrupt proceedings. Code of Civil Procedure 120985. Court this time has been sentenced to the defendant 2 days in
Bro. Okay, we can't do no more of that. Sorry. Killing me on that one, broski.
So what I heard was you were there to apologize to the court. I think I remember you telling her specifically you weren't going to apologize to the court.
100%.
All right. Okay.
Yeah, guys.
Okay. So now we have that going on. That's the contempt.
Do you want me to tell them what happened after that, immediately after that?
Yeah, go ahead.
It's important. All right, so they arrested me in contempt right then and there. They remanded me to county jail. This was a Thursday evening when this happened. Around 4 p.m. is when I was arrested. By the way, I'm a single dad, so my daughter had no clue that I was being arrested. Fortunately, she is 14, so she's somewhat old enough to kind of be safe. And she was with my friend who had picked her up from her doctor's appointment. That's why I had got the continuance earlier in the day that the judge mentioned, that he granted. And my daughter was safe, right? So I got arrested. I went to jail, blah, blah, blah. I called my daughter, got her to a safe place with my family to pick her up, and now she's taken care of. Mind you, he said 2 days in county jail. It's Thursday, which means I would have had to spend the whole weekend in jail. However, while I was in jail for about 12 hours, and then they released me the next morning at about 9 to 10 a.m. And when they released me, one of the officers mentioned to me before they released me, they moved me from the 12-hour holding cell that they keep you in. Then they put me in a room upstairs separate from public housing, right? Because it's a separate thing. And while I was in there, the officer came and said, "Hey, you're getting out pretty soon. They're getting your discharge papers, whatever." And he's like, "Hey, they dropped all the charges." And I was like, "No, they didn't. Quit fucking with me." He's like, "No, I'm serious. They dropped all the charges." I'm like, "Bro, why are you lying to me? That's fucked up." He's like, "No, like I'm not lying to you, man. Why, like, what would it benefit me to lie to you? Like, I just checked the system and all the charges disappeared." And I said, "Are you serious right now? That's them doing the right thing. They wouldn't do that." He said, "Yes." He said, "That's what happened." And so I was like, "What the fuck is going on? Like, did I win? Are they giving up? You know?" And so they go to let me out. I get out the next morning, which is sooner than, what they wanted me to be, right? So I'm thinking, okay, he might be fucking being telling the truth because they're letting me out right now. And when I go to sign my inventory to get my stuff back, what the DA did is they slipped either an arbitration agreement, it was a dismissal notice, it was an offer of dismissal underneath my inventory that they tried to get me to sign, right? And you guys probably know in contract law, if I signed it, everything within that stack of papers I'm signing for, right? If it's attached, if it's clipped. Well, I was privy to this, thank God. And I seen this big old stack of papers underneath my inventory sheet. And I'm like, I looked at the cop. I'm like, hold on, what is all this? He's like, man, just sign. We're trying to get you out of here as quick as possible. And I'm like, hold on, dude, I need to look at this. And by the way, he was kind of holding it when he wanted me to sign, right? So he's kind of holding me. He's kind of holding it. And I'm thinking like, why are you holding it? Why don't you let it go and let me look at it? And I'm like, I can't sign right now. I need to look at what's in here. And he's like, all right, whatever. And he drops it on the table and he's got an attitude. I'm like, I don't know why you got an attitude anyways. He's like, man, I got things to do. We're trying to get you out of here. At this point, I know. I'm like, okay, let me look through this. On like the third page, I see a notice of dismissal for unlawful warrant, right? Or for invalid warrant. And then I keep going through, and then I see underneath, like a few pages under, arbitration agreement, and then a no retaliation clause, and some other stuff. And I was like, I gotta look through all this, man. This is a lot of paperwork. I gotta look through all this. I was like, can I get a copy of this? He's like, no. What do you mean? No, you can't get a copy. And I'm trying to get to my daughter. So I signed with a reservation of all rights and I put under duress and coercion. I asked him, is your body cam on? He said, yes. And so I was like, okay, you're recording for a reason because you wouldn't typically be having your body cam on, necessarily. Maybe you would, I don't know. But you're recording. And so I signed under duress and coercion. And so when I handed it back to him, he read it out loud, probably for his body cam. And because I'm assuming they would have used that in future federal actions, right? And he's like, under duress and coercion. I said, yes, you told me I couldn't have my stuff and I couldn't be released unless I signed my inventory sheet and all this stuff's attached to it. And you won't let me sign it without it being attached to it. So I'm reserving all my rights and I do not consent to any of the contract. And so, really interesting, right, guys? Real fucking interesting. I now I
Yep, that's
don't
what they do.
no, I didn't subpoena the body cam yet of that officer, so I don't have that encounter yet. But yeah, that happened, and I'm thinking, okay, case dismissed. They're gonna drop all the charges. Nope, they kept going. They kept going.
No, they wanted you to sign that so you can't sue them later.
Exactly, and I knew it. And as soon as I didn't sign it the way they wanted me to sign it, they said, okay, well, we're not going to dismiss it. Now we got to try something else.
That's why they brought up arbitration.
Yep, exactly. And I knew it. And I knew in that moment, too, what they were doing. So I signed it with a reservation of rights, all rights reserved, UCC 1308. And I also put under duress and coercion. And I made sure to specify why. Cam, in the Discord, the very last thing that I just put in just now at 11 today is the filed petition with all the evidence. If you want to bring that up and let the people decide if they want to look through it, go through it, and whatnot. So yeah, that happened, and here I am, 7-8 months later, and I'm still dealing with this shit. The first appearance I had,
and the couple washcloth in this bag. I probably shouldn't do that. Where should I put them in the truck?
What was the question? I'm sorry.
It's okay. Go ahead. Go ahead, Michael.
So yeah, guys, the first hearing that I had was after the arrest. They let me out. They let me out. I think July 17th happened. They let me out on the 18th, the following morning. And then the first hearing was not until I want to say August 11th or some shit like that. August 9th, I think was the date. And so at that hearing, the judge basically shut me up, didn't let me say anything because I had appointed counsel, right? Even though I had filed a threat of motion within this time. And I had also filed a request for transcripts, and I had filed a demand for stay pending appellate review.
Did you say they gave you 2 days for contempt?
Yeah.
Okay, here's how that works. Because I got arrested for a warrant that turns out for failure to show up for jury duty, and I have a lifetime exemption from jury duty. They wanted me to be on the jury that I was the victim of a stabbing. Okay, so what had happened is they pulled me in at 10 o'clock one night and released me at 2:30 the next day, in the morning. And that counted for 2 days of false imprisonment and false arrest. And I got paid for that. So that's probably why they cut you loose.
Yeah. False imprisonment. Interesting. Okay.
Well, we've had it to where Layla came in. She was a young buck, and she came in and she did a court of appeals on her speeding ticket, and she had challenged that speeding ticket in the court of appeals, and she was found in contempt. And then once she was released, all of her charges were dropped. So we've had that actually happen to where after a contempt charge, one of our members literally had everything dropped based on the bias and prejudice that the judge had imposed in relation to the contempt beforehand.
Yes.
So that's actually happened.
It
That's
makes
a
me
real
wonder
thing.
if she got a stack of papers too, along with hers.
Oh yeah, very true. But I know
Yeah.
she would have signed right anyways. She already said the thing about Layla was that she was very strict on herself on what she was doing. Like she
Yeah.
wasn't finna deviate from that. And she was nothing but like 22. I was like, holy shit, bro. So to see that kind of happening, there's some young bucks out here that's really getting it and on
That's
top of
what we
that
need.
shit,
We need
bro.
the young bucks to get it.
Like
'Cause
she's
they're
no
gonna carry our
she's no
future.
joke. I actually need to reach out to her because she young and she's smart, bro. And she took that bitch all the way to the appeals on her speeding ticket, got contempt, came out on top, and was gonna do a lawsuit with me. I don't like we initiated the complaint and everything. I don't know where she's at right now. Maybe she's just taking a break, but I need to follow up with her. It's just been so many people coming in. So, but yeah, bro.
Yeah.
That's
And when I signed, by the way, when I signed, the cop that was trying to get me to sign the shit, he's like, "You're not going to sign with your long ass signature again, right?" Because when I first, yeah, because when I first went in and they take my inventory, you got to sign that sheet too, and I signed it also with the reservation of rights, all rights reserved, nothing waived. So when I was trying to, he's like, "You're not going to sign it with your long ass signature again, are you?" I'm like, "Why are you worried about how I signed it?" He's like, "Well, do you sign everything like that?" I say, "All legal documents, yes, I do." So yeah, they try all the little shit they try. Um, so guys, to bring you up to speed, if you've not dealt with contempt, well, direct contempt, I should say, if you've not dealt with it or you're not too familiar with the process, the only way to get rid of a direct contempt order is to appeal it by writ of habeas corpus. It's the only way. That's the only remedy that you have. It's to appeal it for via writ of habeas corpus, and you can make the argument of jurisdiction. You can make the argument that the judge was biased. You can make plenty of different arguments, all that you want, but you have to file a writ of habeas corpus in the appeals court, or you can go directly to the Supreme Court of your state, most likely for original proceeding. If your state's constitution has an article that grants that, California does under Article 1, Clause 10, I believe. So, that is the only way to vacate a contempt order and get rid of it. So that is what I did, and I did go to the appeals court, like I told you guys in the beginning. They summarily denied it twice. It's not over though. It's never over. A void act is void. Past, present, future. 20 years from now, I could fucking fight this shit and win. So just don't give up because they told me no twice, and then the third time when I did a petition for reconsideration. They did so. They on the second time they threatened me with sanctions. If
they
you
did.
file again, Yeah,
Yeah.
on the second time I filed, they said it was repetitive, frivolous, and they threatened me with sanctions. Now that might have been warranted because my dumbass included a notice of liability to the appeals courts that if they don't, if I was like, you have a duty and an obligation to perform on this instrument. And if you do not, then you could be liable for this action, right? I probably shouldn't have done that.
Yeah, no.
Um, yeah, I probably shouldn't have done that. They could say that was coercive and this and that. So I was like, okay, they kind of have some grounds for sanctions. So I'm not gonna be bitchy about it. I'm gonna accept it and try and audible and find a way, right? So I
This is
did a
what they
petition for
wrote. This is what they wrote on this nigga though. The petition for writ
yeah,
habeas corpus denied as repetitive. The request for a temporary stay is denied. November 19th, a motion for so that you're showing y'all his shit was denied, y'all, but he kept going. He didn't give up. The motion for an order shortening time and for expedited consideration of this petition is also denied as frivolous. Nonetheless, the petition has been reviewed out of turn, so it could be decided with the motion. Petitioners advise that the filing of any further frivolous motions in this court may result in the imposition of sanctions.
Wow.
Yeah.
yeah.
I thought about tattooing a writ of habeas corpus on my thigh because they're not going to let you freaking research that while you're in jail. And if you just write it out on a piece of paper and a pencil and give it to the deputy, it's served.
Yep.
Yeah, I
Yep.
know.
And also, I'm not.
Those in our packets for when you go to jail.
Yeah.
So
They tried
So
to lock me up for doing the same shit at both my preliminary hearings at district court. Even though even though I never got arraigned. So they turned it into arraignment, and then I, brought up jurisdiction, and they tried to put me in contempt, and I was like, yeah, this ain't even a court of record. There is no contempt. But anyway, both times they locked me up, told me I was going to jail, and I said, well, I would just like to remind the judge of Tresevant versus City of Tampa, and it's $25,000 every 23 minutes, and I was out in 5-10 minutes.
Nice.
But I don't know if that was direct tied or it was just their tactic of intimidation. But either way, I never went anywhere. And I was only in a holding cell for like 5 minutes.
yep. And you guys are absolutely right. This is their tactics: dilatory delay, perseverance, strain you out, make you feel like the system's against you and that you're defeated. Because I'm gonna tell you what, guys, I absolutely was stressing the fuck out when I was denied twice, and the second time they threatened me with sanctions, I was stressing the fuck out, and I was like, God dang it, like the whole system's against me. I know I'm right. I know what the law says. I know what the evidence says, but I can't get fucking remedy anywhere. And I that's when I started working with Cam. And then Cam, he enlightened me on some like procedural aspects, right? So a big thing that he kind of enlightened me on, and he probably don't even know he enlightened me on this, is it's not always about what you say, it's how you say it. It's about the procedural aspects on how you go about it. And the structure of the document really matters just as much as the substantive portion of it. And so after the threat of sanctions, I was like, okay, I need to restructure this and remove the notice of liability and focus on the evidentiary weight and just make it simple so that I'm not over complicating it and I'm making it very simple. And I filed a motion for reconsideration or a petition for reconsideration after the sanctions threat, and the clerk denied it. He didn't even file it. He denied it and gave me a message stating that a summary denial without a merits adjudication is final and conclusive in the appeals court. So thankfully I didn't get sanctioned. And I was like, oh, okay, cool. That's giving me something to work with. I could work with that. Now my next step would be to go to the next court. So I started researching the rules of the court and stuff and found that the Supreme Court of California would be the next court. So then we take that next step. And what I did is before filing it, I was like, okay, Mike, learn what you did right the first 2 times and learn what you did wrong. And then let's figure it out. And that's when I constructed this document that Cam's looking at. If you guys want to look at it, review it, or if you want to run it through your AI and ask it to like do an audit of the document and see if what was done right, what may have done wrong, what could have been improved, I encourage you to do so. I would love some feedback. When I ran it through my AI, it gave me a really, really high grade. It basically said that I covered all the major tracks, the issues are properly presented, the evidentiary weight is conclusive and undeniable, and all these things. And when I did this one, I definitely did it as a joint petition for all three, right? Prohibition will because they're proceeding in excess of jurisdiction. It's not been established on the record. Mandate would be that they never submitted a judicial order for the 1538.5 suppression motion where the judge found probable cause, because probable cause needs to be a judicial determination that's signed and placed on the record. And that didn't happen. So mandamus would issue to mandate the court to produce that. And then habeas corpus is to void the contempt order. If you guys want to like check out my arguments and all that stuff, there's a table of contents, a table of authorities that can kind of, if you want to learn, if you want to look at it and see if there's anything applicable to you in your cases, or if you might know somebody who may be going through a similar situation, or if you're just like a student of the game and you want to just let me see what he put, because I will be updating you guys. If this is successful, I'll be updating you.
Yep.
And it'll be good to know, because I think Ralph mentioned it about Ralph or Joe. I think it was Joe mentioned it about having the contempt statutes on hand ahead of time. That way, if they threaten you with it, you know, hey, I got it right here. This is what it says. At what point did I do this, right? And you can also know to kind of be weary that they're going to try and do this. They're going to try and hold you in contempt. They're going to threaten you. So reading those statutes and being knowledgeable of the contempt statutes of your state will help you articulate while avoiding things that they may be able to use against you, right? Because it's that the common phrase, what you say can and will be used against you. Well, it goes the same way for fucking them too. So this document, I think, does a very good job at addressing three major issues that a lot of people may face that could be very, sorry, my daughter's calling me. That could be very helpful for you guys if you guys want to study it.
Yeah, there's no doubt. 100%. And that's why I really wanted to bring forth, your whole situation in and of itself, because again, of course you're in California, but when you're having such issues that come with the court, in any form or fashion, you want to see somebody taking it, at a full-fledged battle. You want to see someone taking each proper step to saying, hey, where am I going to get remedy at? Yeah. And although I do think maybe, it would have been really nice to see a disqualification come through, a good suppression off of fruit of the poisonous tree to come through, and cross-examination direct on maybe that doctrine, and having that be a little bit more applicable as far as when it went from consensual to non-consensual, more Rodriguez. Like, I don't know, just some things that would have, I feel like, had a little bit stronger arguments. But you were going more of the procedural, and I understand that, and you were wanting to bring in some things that have validity, but the courts don't want to listen to, where it's a little bit more of a problem. But you did amazing, I know that much, and
yeah, you did very well.
Yeah,
one thing that's sticking out to me is the
Yeah.
fact that you pointed out that you were a combat vet. Just by that statement, that means you are a U.S. citizen under the 14th Amendment. You know what I mean? That's something that you might want to remedy in the future.
Yeah, I'm working on it. I'm working on correcting my status as a state national.
Okay.
Yeah, I have a passport appointment on Thursday this week, actually.
Yeah.
Where I'm gonna get my state national passport, and then I have the affidavit already drafted to send to the state county clerk and all that good stuff. So
yeah, I have a one page act of expatriation, allegiance, and domicile to the Republic of California. And I do it under the letters of confederation and the previous treaties and the 4 organic laws, where I am determined to be a free inhabitant. So
straight up.
And that's something you have to serve on all parties, right?
Oh yeah, I entered it in as an exhibit.
And did you get that apostoled?
I recorded it at in Pima County, Arizona, because my county is so corrupt they won't record nothing.
Huh.
So it's all part of my status correction way I went about doing it. You know what I mean? So Everybody has their own way, but you got to make sure all your I's are dotted and all your T's are crossed.
For sure, for sure. So, final words, Mike, knowing where you're at right now and everything that you've been doing, it's pretty amazing to see the power and the growth and the strength to continuously carry on and to not allow, you got to stand on something, because once you stand on something and you have a good faith record of everything, you can bring it forth later, right? And so, with all that being said, like, what are your closing thoughts and closing words thus far for this Wisedome meeting?
Yeah, so first of all, I want to thank you, Cam, for having me on. I really appreciate your platform and what you're doing. I appreciate your guidance. I appreciate your brotherhood. I want to thank you to all the Wisedome members who are still here today and actually took the time out of their day to just let me present something to them that they may find interesting, or I hope you got some insight from it. I hope at least it was entertaining for you. Um, to say like, holy shit, like this, they're doing this shit out here, and this guy is really not backing down, because yeah, there's no quitting me. So when you're right and you know you're right, and when you really just can't back down. And one of the closing statements that I'll say is, I told you guys about that second denial at the appeals court when they threatened with sanctions. That was one of the low points for me in this whole issue, right, in this whole matter. And what really turned it around was kind of talking to other people, getting some guidance, getting some structure. And it's okay to get down and think that, like, you know what, you're not doing things right. Maybe I'm messing up somewhere. But man, you gotta figure it out, and don't be afraid to say, I was wrong here. Be truthful to yourself, like I told you guys with that notice of liability I included the second time. Probably shouldn't have done that, right? It's okay to make these mistakes. You gotta correct it though.
You're just human.
And just to follow up on that, like Russell Hess, he just got a response back recently from the state on his appeal. And in that response, it was pretty funny because he filed a 21-page, I think, brief or motion to dismiss. And the only thing that the state responded with thus far is to point out that 2 case law citations were paraphrased incorrectly. And what's interesting about that is they just overlooked the whole substance of everything and almost, in a sense, tacitly accepted everything else that was brought forth by just pointing out minor errors. But even in those minor errors, all you got to do is we developed a good faith. Hey, court, as pro se litigants, sometimes things get misplaced in pleadings. And those were some things that were just misplaced. It wasn't intentional, right? I'm not a bar attorney. And so, and when you operate like that, it's completely different rather than just saying, I intentionally, was trying to misquote or mischaracterize. That's not how this goes, man. We're pro se. You have to give us, it's not
on my filings, I always make sure I put in small print is on the first page that I reserve the right to amend.
Yeah, reserve the right to amend or change. Yeah, for sure.
Guys, can you hear me?
Yeah.
Question. Somebody said something about you impeaching somebody in the courtroom if something about U.S. citizen. Can somebody repeat that again?
Well, we could go over that in a moment, but so what I wanted to do is I wanted to commend you, Michael, for everything, bro. You out here fighting, you out here really doing it. You appeals all the way up to the Supreme Court, getting it back remanded down, like you out here grinding, bro. And you definitely part of Wisedome. I am you, we are us, we are all part of one. And I commend you, bro. I think we all do. So if everybody can just say good job or unmute and just say, congratulations getting us far, Michael. Thank you. Whatever you want to say, man. We're going to sign off.
Michael, thanks for sharing your experience, bro.
Yeah.
Thank you, Michael.
Thank you, guys.
I appreciate you.
Michael, if
Hope
you have
this was
any further
simple.
questions, you could always reach out to me.
Hey, thank you so much, Ralph. I really appreciate it. I will quick sidebar. I do think on my after studying this petition that I filed into the Supreme Court that got remanded down, I did miscite one of the cases. So I do need to correct it because I know they're going to come back on page 32, People versus Smith. I was actually looking at it while we was doing this
thing. I did miscite that, so that is improper citation. I have a feeling they will try to state that. So Cam just mentioned something about like, good faith effort. It wasn't my intent. It was a mistake, right? I have and Ralph also mentioned what they're going to do is wait 2 to 4 days before the hearing and then make their decision, which I know they're going to do. That's what they did last time. Does anybody have any procedural insight on if I should file a notice of errata right now?
Right now.
Okay.
Okay.
Yeah.
All right.
That's why I always put that right to reserve.
Oh, son
Okay. Hold on.
brushes
So we're signing out. Y'all say
pero
bye.
son nuevos, vea, para limpiar. The
Yeah,
ones que dijiste, los de colores.
Oh no.
Bueno, los de colores,
Okay. So we're signing out. Y'all say bye world or bye YouTube or bye Wisedome.
Bye
Whatever.
YouTube.
All right, everybody.
See you later,
Bye. Thanks for
Americans.
watching. I hope it was insightful.
Later, YouTube.
Sayonara.